directs that that plan is to be developed by the department in consultation with the Minister of Finance. So that was the second main amendment. Those amendments have gone through. Of course, the respondents don't necessarily concede that relief, but the amendment has gone through. My Lord, if I may then seek to provide a roadmap to what is a relatively broad case. And we will endeavour in our oral argument to focus on those issues that we consider to be decisive for the outcome of each issue and each part of the relief that we see. I will commence, my Lord, with an overview of the case, what it is and is not about. I will then deal with the history of the social relief of the distress grant. Third, I will deal with the question of policy and the proper role of Treasury in this matter. Fourth, I will deal with the right to social assistance. Fifth, I will then deal with the discrete challenges to the regulations that we submit constitute barriers to eligible applicants receiving the grant. I will then deal with the issue of grant value and the issue of the means threshold. At that point, my Lord, I will deal with what in our submission are the two key arguments advanced by the respondents in opposition to the application. The question of affordability and the suggestion that the SRD grant is temporary in nature and different from the other social grants. At that point, my Lord, I will yield to my learned friend Mr. Mkiwa with your leave to deal with the issue of non-payment, systemic non-payment, before I return, my Lord, finally to make brief submissions on revenue and costs. My Lord, we commence then with submissions on what the case is about and what it is not about, and the proper approach to it. My Lord, this application affects the fundamental rights of millions of people living in South Africa. Approximately 7 to 8 million people currently receiving the social relief of distress grant, currently in the amount of 370 Rand. And a similar number of people, my Lord, in the region of 8 million people who are eligible for the grant but currently not receiving it. My Lord, the affected persons constitute the most vulnerable members of our society. They are people, my Lord, who by definition are surviving each month, either on the amount of 370 Rand, they have no other income, or at the very most, my Lord, on 370 Rand plus 623 Rand, which would bring them 1 Rand within the means threshold. In other words, my Lord, these are people who survive on at most under 1,000 Rand a month. And those are the people with whom this application is concerned. My Lord, the case is concerned with 3 broad sets of issues. The first set of issues are specific regulations that we submit constitute barriers for eligible persons to access the grant. So these are regulations that are keeping people who ought to be getting the grant from doing so. The second set of issues, my Lord, concern the grant value and the income threshold, the means threshold. The grant value currently being set at 370 Rand and the means threshold at 624 Rand. The third and final issue, my Lord, is not about the regulations themselves, but about their implementation. And that is concerned with systemic non-payment of, at times, approximately 15% of grant recipients, hundreds of thousands, sometimes 1 million people who've been approved for the grant and do not receive payment or receive it after a substantial delay. And it's that issue, my Lord, that my learned friend Mr. Mkiwa will address. My Lord, those are the issues before your Lordship. challenge to the regulations, and a question of its implementation around non-payment. My Lord, we draw guidance in terms of the proper approach of the parties to such a matter from the decision of His Lordship Justice of Appeal Cameron, as he then was, in Permanent Secretary versus Musa. And I would take your Lordship there. It appears in our abridged bundle, my Lord. From page 165, and I would take your Lordship to page 171. My Lord, this matter concerns systemic non-payment of disability grants. It is indeed, my Lord. Yes, my Lord. Your Lordship will see that we've retained the case lines pagination in addition to our own new bundle pagination. So the case lines pagination is 0211127. Page. That is the page that we will refer to, my Lord. My Lord, the matter concerned disability grants and systemic problems around their non-payment. It was an attempt to certify, a successful attempt to certify a class action around those disability grants. My Lord, we draw guidance from it on what the Supreme Court of Appeal directs all of the litigants in a matter such as this and their representatives to do in their conduct of the case. And we refer, my Lord, to paragraphs 14 and 15, where Judge of Appeal Cameron held as follows. The circumstances of this particular case, unlawful conduct by a party against a disparate body of claimants lacking access to individualized legal services, with small claims unsuitable for, if not incapable of enforcement in isolation, should have led to the conclusion, in short order, that the applicant's assertion of authority to institute class action proceedings was unassailable. But assail their claim the province did. It did so by recourse to every stratagem and device and obstruction, every legal argument and non-argument that it thought lay to hand, while offering no undertaking to implement Bushula, an earlier decision, in relation to the applicant class. It asserted that because of the decision the relief sought was moot. It then contended, contradictorily, that the applicant's claim was not yet ripe for adjudication. It tendered no evidence to refute the mass of indicia the applicants placed before the court that showed unlawful conduct against huge numbers of disability pensioners, yet argued that the applicant's evidence was inadmissible hearsay. It obstructed the applicant class's entitlement to be spared physical destitution, yet invoked their privacy rights in contending that the disclosure order should not have been granted. It did not flinch even from deriding the first applicant, who adhered to the founding papers with his thumbprint. Its deponent thought fit to record his doubt that Mr. Musa had read the media articles appended to the papers, a claim the first applicant did not make, while the written argument stated that it boggles the mind that a man who never attended school and is presently illiterate is able to make learned submissions. And the court continues in paragraph 15. All this speaks of a contempt for people and process that does not befit an organ of government under our constitutional dispensation. It is not the function of the courts to criticize government's decisions in the area of social policy, but when an organ of government invokes legal processes to impede the rightful claims of its citizens, it not only defies the Constitution, which commands all organs of state to be loyal to the Constitution, and requires that public administration be conducted on the basis that people's needs must be responded to. It also misuses the mechanisms of the law, which it is the responsibility of the courts to safeguard. The province's approach to these proceedings was contradictory, cynical, expedient, and obstructionist. It conducted the case as though it were at war with its own citizens, the more shamefully because those it was combating were, in terms of secular hierarchies and affluence and power, the least in its sphere. We were told in extenuation that unentitled claimants were costing the province 65 million rand per month, that misses the point, which is the cost the province's remedy exacted in human suffering on those who are entitled to benefits. What is more, the extravagant cost of ghost claims would seem to justify the expense of imperative administrative measures to remedy the problem by singling out the bogus, something the province conspicuously failed to do. It cannot warrant unlawful action against the entitled. My Lord, there are some parallels and some differences, of course. We'll return to the parallels. My Lord, in similar vein, and I won't take your Lordship through it in as much detail, but the Constitutional Court in Njongi versus a member of the Executive Council issued a similar injunction to organs of state litigating matters again involving social grants. My Lord, this is not a matter referred to in our heads of argument, so I will provide the full citation. It's Njongi versus MEC, Department of Welfare, Eastern Cape, reported as 2008, Volume 4, South African Law Reports, 237, decision of the Constitutional Court. It was a unanimous decision penned by Justice Yaku. And my Lord, the issue there was that it again concerned the same disability grants. It was a later judgment in the same line. And the state in that matter, my Lord, had raised prescription against the disability grant recipients. It had pleaded prescription. And what Justice Yaku reminded all of us in that matter, my Lord, is that a decision by the state, and this is at paragraph 79, a decision by the state whether or not to invoke prescription in a particular case must be informed by the values of our Constitution. Justice Yaku described this as a moral decision that must be taken, but against the values of the Constitution. And the court referred to factors that the organ of state raising prescription ought to have taken into account in deciding whether or not to raise prescription. That the applicant was poor and vulnerable, that she lived with a permanent disability, that the grant that was payable to her was constitutionally obligatory, and that arrears had accrued as a result of unlawful administrative action by the provincial government. And the Constitutional Court emphasized that all of these factors ought to have been put in the balance and ought to have been evaluated in the context of deciding whether to raise prescription against Mrs. Njongi, the applicant in that matter, saying that to be held in poverty is a cursed condition. Quite apart from the physical discomfort of deprivation, it reduces a human in his or her dignity. My Lord, we refer as our point of departure to the Supreme Court of Appeal's decision in Muza and the Constitutional Court judgment in Njongi to remind us all, my Lord, all of the parties in this matter, all of their representatives, all of the litigants present in court or observing the hearing, that this is not, my Lord, an ordinary matter, an ordinary motion on your Lordship's roll, in which it's appropriate for litigants to take technical points at the cost of the rights of the grant beneficiaries. We submit, my Lord, that there rests on all of us a solemn responsibility as the parties, as their representatives, to approach this matter with a focus on the rights of the grant beneficiaries, with a focus on how to fix the problems in the administration of the Social Relief of Distress grant. My Lord, in light of that, we welcome the fact that National Treasury has abandoned several of the technical points related to pleading, the relief in the notice of motion, and that we understand it has conceded part of the relief sought by the applicants, and I'll come to that in a moment. However, my Lord, we will submit that the conduct of the Department and SASA in this matter regrettably falls short of what is constitutionally required of it. And we invite the Department and SASA to refocus its approach through the conduct of this hearing over the next 2 days on how to fix the problems, on suggesting constructive solutions, on taking seriously the evidence of the applicants. My Lord, it's our understanding that certain of the relief has, at this point, as we come to argue the matter, been conceded by the respondents in various ways. And I'll note those at the outset. My Lord, my learned friend Mr. Marcus has indicated to us, and this follows from the approach that they took in their affidavits and heads, that National Treasury concedes the challenge regarding the exclusion of new evidence on appeal, that specific issue, the narrow appeal issue. And it's our understanding, and the learned friend will speak in due course, that they accept that that regulation is problematic. No doubt, my Lord, they will argue that fixing that problem by allowing new evidence on appeal will fix many of the other problems, or mitigate them. And we'll deal with that when we get to the issue of appeal. But on the question of concessions, my Lord, in relation to the issue of the definition of insufficient means, income and financial support, we understand that National Treasury accepts in its affidavits and heads that these terms cannot include funds held on behalf of another person. So if you have funds in your bank account because you've received them on behalf of your sister, as in the case of some of the individuals, it's our understanding that they accept in principle that that ought not to be part of the definition of the term. And my Lord, on the same issue, it's our understanding that the Department and SASA accept that those defined terms do not include child support grants. So at least those forms of monies received, my Lord, it's our understanding that the respondents to that extent accept that they ought not to be included in the definitions. The definition which is otherwise stated to be any money received for any purpose, from any person, for any reason. But we understand that those two concessions have been made in the papers and in heads. My Lord, we invite the respondents to suggest language in relation to the draft order to capture those exclusions from the terms. And we do so at the outset. My Lord, the third concession has been made, we submit, by conduct, if not by words. Following the exchange of all of the affidavits, up to the point of the replying affidavit, my Lord, the grant value remained at 350 Rand. It had been so for 4 years. But at the time of shortly before the filing of the replying affidavit, the Minister of Finance announced an increase of 20 Rand to take the grant value to 370 Rand. And my Lord, the supplementary affidavits then deal with that issue of the 20 Rand increase. Our supplementary affidavit puts up the amendment regulations, and Treasury's supplementary affidavit explains or seeks to explain that 20 Rand increase. I'll deal with that in due course, but my Lord, it's, we note at this stage, that by their conduct, that increase constitutes a partial concession. We say that it doesn't go far enough, and we will persist in seeking relief in relation to the grant value, which will be forward-looking relief. But we note that conduct at the outset. In general, my Lord, we argue that these three concessions do not go far enough. They will not address the rights violations suffered by the 8 million or so people who are receiving the grant, or the violations, perhaps even more egregious, of the similar number of people who are barred from accessing the grant. And the remainder of our relief seeks to address and remedy those rights violations. Now, Lord, what then is the case about? And we submit that it is really about those three issues that I've already identified, three categories of issues. The first concerns the regulations that provide barriers to access to applicants. The second set, the grant value and the income threshold. And the third set, the systemic problems of non-payment. We've identified those as the three sets of issues. But it's important, my Lord, at the outset, to clear away some clutter of issues that the case is not about, that your Lordship, with respect, does not have to decide, although they have been raised in particular by the respondents on the papers. And they're not necessary to decide because we do not seek relief in relation to them, and because they are factual questions that are not necessary to determine in order to grant the relief that we seek. And they are the following, my Lord. First, what the precise rand value of the grant should be. We do not ask the court to determine the grant value, nor do we seek to prescribe it ourselves. In similar vein, second, my Lord, the precise qualifying threshold, the means threshold. We do not ask the court to determine what it ought to be. In relation to those issues, it is a limited finding that the current thresholds are inadequate, that they are unconstitutional. My Lord, the third question that this case is not about, that is not required to be decided, is how much government can or should budget for the social relief of distress grant. An issue that National Treasury devotes a great deal of attention to. And similarly, fourth, my Lord, whether government can raise funds from other sources. Treasury raised that question, and we've responded to it in part in our replying affidavit, my Lord. But when we did so on all of these questions, we took the position by which we stand that these are not questions that the court needs to decide. The fifth, my Lord, similarly, is whether government needs to allocate funds from other expenditure to social grants. This court does not need to decide that. And sixth, my Lord, though it is a major issue of policy for the country, this court does not need to decide whether South Africa can or should introduce a universal basic income grant to replace the social relief of distress grant. And my Lord, this is an issue that the Department and SASSA address at some length in their heads of argument and in their affidavits. And my Lord, with respect, they appear to have misunderstood our references to the basic income guarantee. It is part of the context. It is part of the policy discussions that are happening in government. But it's not part of the relief that we seek, my Lord. There is no order that we seek that has anything to do with the basic income guarantee. Government may in time move towards one. Those are the strong indications. And it is indeed so that the Institute for Economic Justice and Pay the Grants have advocated for such a move. But it's not relief sought in this case. It's not an issue that the court needs to decide. No time need be spent on it. My Lord, all of those 6 questions are issues that receive ventilation, particularly in their heads, but they don't require determination. And my Lord, in large respects, that is because of the nature of the relief that we seek. And we have characterized that relief as modest. And our learned friends from National Treasury take issue with that. They say our relief is particularly far-reaching. We will deal with the relief in due course and show that it is not. But at this stage, my Lord, we make the submission that the relief is modest because all that we are asking the court to do is what courts routinely do in matters relating to regulations, in matters indeed relating to social grants, which is to strike down those regulations that are procedurally unfair or arbitrarily exclude people in relation to the first set of issues. In relation to the second set of issues, We're not asking the court to determine the grant value or the means threshold. We're asking the court modestly to direct the department, in consultation with the Minister of Finance, to develop a plan to remedy the retrogression and to progressively realize those two values, the grant value and the means threshold, both of which have been allowed to stagnate for these several years. But the relief is only a plan, my lord. Relief routinely granted in matters of this nature. And in relation to the third issue, Lord, the systemic non-payment, we similarly seek structural interdict that invites the department and SASSA to take seriously the fact that hundreds of thousands of approved beneficiaries each month are not being paid, and for them to identify suitable solutions to those problems. My Lord, the relief is broad because there are a range of issues, but it is modest in separation of powers terms. We do not seek to usurp the functions of the department, which holds a crucial role in our constitutional democracy, and nor do we invite the court to do so with respect. My Lord, the matter does, however, span a series of discrete issues, and we emphasize at the outset that each of those issues is discrete. Each of the challenges to the regulations stands or falls on its own merits, whether it's the online only or the appeal issue, the grant value, they each stand or fall on their own merits. This is not a single issue case. And at times, my Lord, the language of the respondents in argument in particular is to the effect that the SRD grant, the regulations are a reasonable measure. Lord, we submit with respect that that seeks to oversimplify the case into a single issue case. It is not a single issue case. There are commonalities and overlaps, but each of the issues is discrete and stands or falls on its own merits. Each one requires justification from the state. My Lord, as we understand part of their opposition, each of the sets of respondents rely on really one primary argument. From National Treasury, it's affordability. And they argue that none of the relief is affordable, and effectively that the grant regulations should be left as they are, without any court intervention, save for the limited concessions that I identified at the outset. Lord, from the department and SASSA, the primary argument is that this social relief of distress grant is a different type of creature to all the other social grants, and it is temporary in nature. It can be treated differently, and because it's temporary by implication, there's no point really fixing any problems with it, because it may not be around. And we will devote specific attention to each of those arguments, but we highlight them up front because they run through on the discrete issues. Lord, we will submit that the respondents are seeking to immunize the SRD grant from court scrutiny and seeking to avoid appropriate accountability for the massive arbitrary exclusions and the stagnating grant value and income threshold. In doing so, my Lord, the respondents invite this court to ignore 5 crucial areas of evidence or law. Aspects that they either don't deal with or that they try to invite the court to disregard. And the five areas are the following, my Lord. The first are the repeated formal public statements by public office bearers about the future of the grant, the SRD grant. Public statements that articulate with absolute clarity government's policy position in relation to the SRD grant.
My Lord, those are statements by His Excellency the President, by the Minister of Social Development at the time, Zulu, by DSD officials, including senior officials, and even by the Minister of Finance. My Lord, I'll deal with those statements in more detail later, but let me state up front that the substance of those policy statements is clear and it is consistent. And it is this, my Lord. It is that the social relief of distress grant is being retained, extended and improved progressively, indefinitely, until and unless it is replaced by something better, which, although this has not been finally decided in government, the statements by all of those officials indicate is likely to be a universal basic income guarantee. That is not an issue that this court needs to decide. What comes next? Relevant part is that those public statements indicate that the SRD grant is far from temporary, and that it is to be incrementally improved, extended, and strengthened. To deal with the content of the statements earlier, I make the submission at this stage that both National Treasury and the Department and SASSA effectively invite this court to disregard all of those public formal statements, statements made in the State of the Nation address by the President, in Parliament by the Minister, in parliamentary committee briefings by department officials, and instead to take what is said in heads of argument or in a throwaway line in an answering affidavit from one of the respondents, unsupported by any evidence that the grant is temporary. That's the first aspect, my Lord, they invite this court to ignore, and that we submit with respect cannot be ignored. The second, my Lord, which is substantially downplayed by the respondents and disregarded, is the evidence from government itself, primarily from DSD and SASSA, about the massive arbitrary exclusions, the exclusion errors, and the failures even to pay approved beneficiaries. It receives very little attention, my Lord. My Lord, we started with injunction to all of us as participants in these proceedings that the duty is to fix the problems. Those are the problems, and they seek to ignore them, massively downplay them. The third area that they ignore, my Lord, they don't even give it the courtesy of a response on oath, is the evidence of 80 individual grant beneficiaries filed supporting affidavits. My Lord, there's a procedural Plaskon-Evans dimension to that. That evidence is unanswered, must be taken, this will be accepted. But there is a deeper issue there, my Lord, about the dignity and rights of those 80 individuals who are not given the courtesy of a response, of an investigation into why they didn't receive the grant, for example, why their appeal has not been decided. Lord, that aspect relates primarily, of course, to the Department and SASSA rather than Treasury. It's beyond Treasury's now. The fourth issue, my Lord, sorry, my Lord, is that on the issue of the non-payment? Lord, the explanations are unclear. My learned friend, Mr. Mbikiwa, will deal with it in more detail. But what we will show is that over an extended period, the non-payments were substantial, up to 15% approved beneficiaries not being paid. The precise reasons for the non-payments are difficult to discern. That's why we've proposed a remedy that requires them to investigate, report on those problems, and then address them. With your leave, my Lord, my learned friend will address the question in more detail with reference to the evidence. My Lord, the fourth issue that has largely been downplayed, though not ignored, is government's own decision, belatedly, shortly in the period between close of pleadings and argument, to increase the grant by 20 Rand. Let me deal with that issue briefly now, my Lord. We have resolved, I think, the procedural differences between the parties around the supplementary affidavit. We were criticized initially, my Lord, for putting up the supplementary affidavit, and National Treasury reads that affidavit as suggesting dishonesty. That's not our submission. I'll deal with our submission in due course. The question, my Lord, is an explanation for that 20 Rand increase. That explanation has now been forthcoming, but from National Treasury, pursuant to our invitation to them to file a further supplementary. So we filed our supplementary, we delivered heads. We had regard to their heads of argument, which took issue. And we subsequently wrote to the State Attorney on behalf of respondents, inviting them to deliver a supplementary affidavit, explaining the 20 Rand increase to the extent that they seek to do so. And they have now done so. So to that extent, we have something to engage with. We will submit that the explanation actually demonstrates that the relief that we seek can competently be sought. The fifth issue, my Lord, that is substantially downplayed are South Africa's international law obligations. Not addressed by the Departmental and SASSA, direct way. The National Treasury effectively responds to those international law obligations by saying that they are only persuasive, that because they haven't been incorporated as domestic legislation, really very little regard need be had to them. And, my Lord, we submit that that's inconsistent with the approach in our law to international law in relation to the Bill of Rights. Courts must consider international law. Very relevant to the interpretation of the Bill of Rights. We're here dealing with binding international law obligations under the International Covenant on Economic, Social and Cultural Rights and the African Charter. I'll make some submissions on that in due course. This introductory submission, my Lord, is to point out that these 5 important parts of the case have not really been addressed. They're either deliberately disregarded or they're substantially downplayed by the respondents, and we submit without justification. And my Lord, make the submission that having disregarded key aspects of the evidence and law that are required and that are determinative, National Treasury instead raises a number of red herrings. And I've listed the questions that this court does not need to decide. We agree with Treasury that these are not appropriate questions for a court, that exactly how much should be budgeted and when is not a question that this court needs to decide, what sources the funding should be granted from. In essence, my Lord, those core economic questions lie in the expertise of the relevant organs of state, and the powers must be exercised there. So much of the argument and the papers around those economic questions is a shoal of red herrings. Lord, ultimately, this court is, of course, a court of law, and it is called upon with respect to decide legal questions, whether the impugned regulations are consistent with the Constitution or not, whether there is systemic non-payment, and if so, what appropriate relief to grant. Questions appropriately reserved for courts in our constitutional democracy. Questions which courts have on many occasions been forced to confront in relation to social grants and in relation to other social rights issues. Lord, those are our introductory submissions of what the case is about, what it is not about. what ultimately lies for decision. Turn now, my Lord, to deal with really the factual background, the history of this grant. Lord, we submit at the outset that these facts are, with very few exceptions, common cause, almost entirely common cause. They're admitted, they mainly come from government. The sources are government sources. We did put up in the founding papers a detailed history of the grant, reasons for its adoption, the context and its impact. Those facts have been admitted entirely by National Treasury, and the Department of Social Development either admits them or, rather curiously, it pleads no knowledge, including of some of its own statistics and its own reports. SASSA, in its separate affidavit, my Lord, put up some limited data of its own. DSD, in its affidavit, put up really no new data. My Lord, referred to judgment in Musa, that responsibility to engage with the data. As we go, we will make the submission, but the department, with respect, has fallen short of its duty to assist the court. Lord, in relation to the facts, National Treasury confined most of its factual submissions to affordability and to a broad perspective on country's economic situation. Broad implications, as they would have it, of the relief that we seek. But the facts are largely common cause that I deal with now. My Lord, we'll emphasize a few key aspects of the trajectory of the grant, because they are, with respect, material. The grant, as is well known, my Lord, is called the COVID-19 Social Relief of Distress Grant because it had its origins in the pandemic. It was adopted in May 2020, at that time under the Disaster Management Act, as part of government's response to the pandemic and the suffering that it caused our people. And my Lord, we make the submission now that government deserves appropriate credit and recognition for discharging its constitutional obligations as it then did by swiftly introducing the Social Relief of Distress Grant. My Lord, respondents, in particular DSD and SASSA, emphasize how swiftly that was done, that it was effective, that it reached millions of people. And let us be clear, my Lord, we welcome and give appropriate acknowledgement to those early benefits, those early gains. Our concerns are with what has happened subsequently. There were a series of extensions, ultimately 6 different iterations of the grant. But crucially, my Lord, the department, government as a whole, recognized that despite the end of the pandemic, underlying issues of poverty and hunger and unemployment persisted. Those had not improved. They did not end when the state of disaster was terminated. My Lord, we deal with some of these statistics, and they're again not in dispute, that 25% of people living in South Africa were living below the food poverty line in 2015, according to SASSA. There's no indication that that figure has materially changed since then. 25% below the food poverty line. 20.4% of the country is food insecure, according to a 2023 study that we cite. 20.9% routinely send a family member to beg for food. 1 in 5. Lord, Treasury admits all of these statistics. The Department of Social Development either does not deny them or pleads no knowledge of them, even where the statistics are within its own domain. So, my Lord, that was the context. That was what faced the government coming out of the pandemic. And in response, my Lord, a decision was taken to retain the grant, but to shift it under the Social Assistance Act. And two things were then done, my Lord. An amendment to Section 4 of the Social Assistance Act to add social relief of distress grant to the list of grants that are administered under that act, put alongside all of the other social grants. And then regulations were from that point, 2022, issued in terms of Section 32 of the Social Assistance Act. Since 2022, my Lord, the grant has taken life from the Social Assistance Act, alongside all of the other grants that government administers, child support, disability, pensioner, war veteran, and so on. And we have since had, my Lord, annual iterations of the regulations with some other amendments in between. So, for example, the 20 Rand increase being the most recent. And my Lord, I should indicate at this stage that we have provided a set of the latest current regulations in the abridged bundle of authorities, the hard copy. It begins from page, it's the third item there following the Constitution and the Act. In the papers, your Lordship will find all the previous iterations of the regulations. The current regulations are those ones. My Lord, we're now dealing with a grant that lives under the Social Assistance Act, like all other grants, and that has been annually extended since 2022. The grant, my Lord, has also faced two previous legal challenges in the Scalabrini case and the Black Sash case, which are dealt with in the papers and in the heads. The Scalabrini case, my Lord, was dealt with the unlawful exclusion of foreign nationals, documented foreign nationals, from the grant. Your Lordship's brother, His Lordship Mr. Justice Factual, found that that exclusion was unconstitutional and unlawful, remedied it, in the process also directing the respondents to cost that, to determine the cost of including documented foreign nationals. So that was the Scalabrini remedy. It brought in a category of people who had been unlawfully excluded. My Lord, it's not part of this case, but we would note that in the end, the numbers of foreign nationals who've accessed the grant have been relatively low, in the region of 20 to 25,000, been relatively low as it happens. But the court had to intervene to strike down regulation that excluded them to remedy that exclusion. The second challenge to the regulations, my Lord, never resulted in a judgment. It was the Black Sash application, which was ultimately settled. Its primary target, my Lord, was the means threshold, which at the time was set at 350 Rand. A little bit confusingly, my Lord, in that iteration, 2021, 2022, the grant value and the means threshold were set the same at 350 Rand. So you had to have means below 350 Rand to qualify to get the grant of 350 Rand. Black Sash application primarily targeted that issue. It was settled and resolved, and the department amended the regulations to raise the grant value to its current value of 624 Rand, which at the time, my Lord, was the food poverty line, 2022. So the department said, we are setting means threshold at the food poverty line, and that application was then withdrawn. My Lord, what has been the impact of the social relief of distress grant up to this point? We made submissions, my Lord, earlier that appropriate credit must be given to the state for the positive impact that the grant has had, those people who have received it. The data reflects, my lord, and this data arises again either from DSD sources or sources that they admit, that the grant lifted 2 to 2.8 million people above the food poverty line in 2021. In 2021, 2 to 2.8 million people were lifted out of the food poverty line. In other words, my lord, on the indicator that government uses really to measure hunger, 2 to 2.8 million people were lifted out of hunger by the grant. My lord, on that score, the grant is very much about food, about the right to food. The data shows that 93% of people use the grant, spend at least a portion of it on food. 93% of the recipients, and over 50% of the grant value, the overall money, is spent on food. 93% of people spend at least some of their grant on food. Overall, at least 50% of the total grants that are received go towards buying food. My lord, the reports from the government also found that the grant improves life prospects, job seeking, and educational opportunities. And former Minister Zulu reported specifically in Parliament on women, her findings and her experience of women starting businesses, small businesses, using a combination of the SRD grant and the child support grant, and lifting their families out of poverty. My lord, the President has recognized the benefits of the grant in boosting township and rural economies and the increased spending in those economies using the grant money. So, my lord, this is a grant that has had substantial impact. We simply submit that the exclusions of people who should be receiving those benefits are unlawful, and that allowing the grant to stagnate has been a profoundly retrogressive step the last 4 years, my lord, which has substantially eroded that impact, reduced the benefits of the grant, and in ways that are unconstitutional. My lord, a key question is the eligible pool. How many people, on data available from government sources, are eligible for the grant? My lord, in this regard, we would take your lordship to Annexure FA 36 to the founding affidavit. This appears at 002 302. 002 302. Lord, the relevant document actually begins on 002291. The page to which we refer your lordship is 302. 002291. Lord, this is a briefing by the department and SASSA themselves on 3 June 2022 to the Parliamentary Portfolio Committee on Social Development. Now, Lord, on this question of the eligible pool, take your lordship to page 302, 002 302. Where in the third bullet point, my lord, the department briefing the Parliamentary Committee reports that according to survey data, there are 13.4 million people with no income and 18.3 million people below the food poverty line. This is the department's best understanding of the eligible pool at that time. This is 2022, my lord, and at that time, the means threshold was set at 624 Rand, following Black Sash, at the food poverty line. So when the department says there are 18.3 million people below the food poverty line, according to survey data, it is saying to us that in 2022, there were 18.3 million people below that means threshold. On its data, my lord. This is its data. Lord, in the founding papers, we put up some independent studies which put that figure at more at around 16 million people. There is also an outlier that puts it closer to 22 million. Lord, it's not a matter that this court needs to finally determine with precision. But if your lordship were to rely on anything, the DSD data seems to us to be the appropriate marker, their figure of 18.3 million. Ultimately, my lord, what is abundantly clear, beyond dispute, is that there are millions of people above the 7 or 8 million who have been receiving the grant, who have an income below the means threshold. People who are eligible, substantively eligible. My lord, we nowhere suggest that it should be reasonably expected that 100% of eligible applicants will apply. We have nowhere suggested that, and nor is our relief based on any misguided assumption that the grant needs to reach 100% of the eligible people. We point to this data, my lord, to show that there are material exclusions, my lord. This is not a handful of people. It is millions of people who are eligible and who are not receiving the grant. And we make this that the impugned regulations are largely responsible for those exclusions. Well, this picture we submit, this factual picture of exclusions, is made very clear from a single table, a single set of statistics. And we take you, my lord, to the founding affidavit at 00249. Well, that's table 2, and the lordship has it. Well, we submit that it paints a picture of the situation very clearly. That's 00249. My lord, what table 2 does is it collates government data from DSD and SASSA sources on the number of applications, number of approvals, payments, the percentage of approvals, how many applications are getting approved as a percentage, and what percentage of people, approved beneficiaries, have been paid when SASSA and the department report on that data. And the final column is the number of applicants approved but not paid. And it goes month by month, my lord, beginning in April 2021 up to May 2023. And my lord, the picture is fairly consistent. It suffices, my lord, to refer your lordship to the 4 latest months, or most recent months in that table, February to May 2023, where we see in February 13.74 million applications, 8.440 million approved, of whom 7.4 million are paid, and the percentage of approvals, my lord, is 61% of the applications that were received by SASSA. So the other 39% were refused. Percentage paid is 88%, so 12% had not been paid, and that came to just over 1 million approved beneficiaries who'd not been paid. In March, my lord, a similar picture, 13.9, just under 4 million applications, 8.5 million approved, payments 7.3 million, the approval rate still at 61%, payment rate at 86%, almost 1.2 million not paid when the data was reported. April 2023, my lord, applications go up a bit to 14.2 million, but approvals go down to 8.2 million. Payments also go down to just over 7 million. Only 58% of applications are approved. 86% are paid, and the number unpaid are 1.164 million. And finally, in May, my lord, again, a similar picture. Applications have gone up a little bit more, 14.4 million applications received, 8.4 million approved, 7.1 million paid, constituting 58% of the applications, 58% approval rate, and 84% payment rate, so 16% are not paid, being 1.3 million by the time of reporting of the data. And my lord, and this may be an appropriate point with your lordship's leave to take the adjournment, but if I may round off on the point. The low rate of approvals. My lord, with respect, they don't offer a clear explanation. What they do concede, my lord, is that there are inaccuracies in the databases and that the bank verification is effectively a blunt instrument, which they rely on for the verification, my lord. My lord, they will also say that undeserving applicants were correctly turned down. But my lord, there's no evidence to quantify those people. What we say, my lord, is that this paints a picture of a system that is broken and a system that requires fixing. My lord, we submit, based on the evidence that we've gathered, which is both statistical research and individual accounts of the 80 individuals and other pay the grant beneficiaries, that the reason that people are being excluded is because of the regulations that we challenge, which are resulting in rejections where people are actually eligible and qualified. Please. Lord, the courtroom, but I imagine there's nothing that can be done about that. They of course blame me for it, but I imagine there's something. Well, let's return then. Well, then a friend will deal with also a number of people, a significant percentage and number not being paid despite being approved. My Lord, which is the last column indeed, my Lord. My Lord, SASSA has put up a similar set of statistics, and I'll just provide you with the reference because the picture we submit there is the same. That appears at 010-25. And they just take the statistics a little bit because they filed after us. Those are statistics up to September 2020. That's it, my Lord. My Lord, the pattern is the same. A similar proportion, similar number of applications, similar proportion of approvals. It's still a very large number, 6-7 million or more not being approved. Months. It doesn't change, basically. My Lord, the department has publicly expressed concern about the low approval rate. Your Lordship's question to me before the break. And I'll provide that reference, my Lord. It's in Annexure FA 39, which is at 002-321. And it's a department media statement at that time expressing concern about approvals being at around 50%. Department expressing its concern and indicating that it needed to address the issue. Look, this picture is, which is already bleak, is made even worse by the appeal statistics, the outcomes of appeals, which I'll take your Lordship to later when I deal with the challenge on the appeal regulation. But the headline, my Lord, is that the outcomes of appeals, favorable, successful appeals, usually less than 1% every month. So around 1 million appeals received each month by the department, and about 1% successful, less than 1%, 0.5, 0.8%. So that broken system, that picture that we see in table 2, millions of people being rejected, is not fixed on appeal, not remedied on appeal by a large number succeeding on appeal. It is not. We'll deal with it in due course, but as we understand it, it's effectively a rerun of the same bank verification and databases. The only difference being that they use the database as at the time of the appeal. So arguably it may have been updated. But we will submit, my Lord, that the brokenness of the system is even more extreme in relation to appeals. And on the basis of common cause facts that we'll get to when we deal with the issue. My Lord, but that is a systemic problem that confronts your Lordship. And Lordship asked, why are there so many rejections? Why is the approval rate so low? What are the explanations from the respondents? What we submit, my Lord, is that each of those regulations that we challenge, so the problematic questions in the questionnaire, problematic definitions of income and financial support, each of those, my Lord, is responsible for some exclusions. Fundamentally, the database of bank verification, with the high levels of errors in those systems, are responsible for those very high percentages of rejections. My Lord, this is what is referred to as exclusion errors. Your Lordship will have come across this term in the department's reports and in argument, exclusion errors and inclusion errors. An exclusion error is when someone who ought to receive the grant, someone meets the requirements, but they are wrongly rejected. That's an exclusion error. An inclusion error, my lord, is when someone who isn't qualified wrongly is approved. My lord, all of the evidence shows that the exclusion errors are very significant. They're very sizable. And my lord, there's no meaningful evidence to show any significant inclusion errors on the papers. By orders of magnitude, my lord. My lord, the next issue that we need to deal with, my lord, and after this, we then turn to the law and the specific challenges to move forwards. But this is a crucial issue, my lord, in relation to the stance of the respective respondents, their appropriate role, and what the court is to make of the positions that they have taken, publicly and in these proceedings. It's really, my lord, about the proper role of the Treasury and the Department. My lord, we made the submission at the outset that both sets of respondents like this court to ignore all of the public formal statements by the President, the Minister, the officials of the Department, and so on, about the policy position on the SRD grant. Lord, the Department and SASSA somewhat surprisingly argued that statements of this sort were effectively electioneering by political parties. It appears to be suggested that the officials didn't mean what they said. If this submission, my lord, applies to State of the Nation addresses, parliamentary Q&A, briefings to portfolio committees, well, we would submit that it's a problematic submission. And, of course, no regard can be had. There's no factual basis for that suggestion that this was electioneering. But, my lord, on the question of what is that policy position, we need to be clear with you, my lord, why we rely on those statements. The Treasury takes issue with our reliance on them and suggests that we're trying to use the policy statements, those public statements, to interpret the regulations and the act. That is not so, Lord. Don't rely on them for that purpose. Rely on them for quite a different purpose, which is what is government's plan around implementing the grant. That is relevant to the remedy. It's relevant to the question of whether the grant is temporary. In other words, whether it might be scrapped tomorrow. But we don't rely on it, Lord, to interpret the law. Policy position, Lord, is also relevant to the systemic non-payment. It basically just goes to what is government's plan. We've submitted that policy position is to us. If it's convenient, I can deal with that issue now. That argument is advanced in particular by the Department of SASSA, but also by National Treasury. So we submit that argument fails for three main reasons. First reason, my lord, is that the grant has the same legal status, it's the same kind of legal animal as the other social grants. So, well, it might have been a different position when it was under the Disaster Management Act during the pandemic. Since 2022, the grant is established in terms of regulations promulgated under the Social Assistance Act. Same as the Child Support Grant, Disability, all of the other grants. The same legal status, it is specifically listed as a type of grant, along with all of the others in Section 4 of the Social Assistance Act. It's of the same nature. And the fact, my lord, that the regulations are amended annually, that is also the same with the other grants. Child Support Grant, a new value is issued each year, a new means threshold, listed in the same way, same kind of legal animal. The second reason, my lord, is that the respondents confused two senses of the word temporary. They lied two different senses of the word temporary. Grant does provide temporary relief for people who are in need. So someone who at that time has income below the means threshold. It's temporary in that sense for that grant beneficiary. And that is the same as all of the other grants too, ones that are means tested. Many of them are means tested. And you only get them while you meet the means test, while you have the need. That sense of temporary reward has nothing to do with the future of the grant as a mechanism, whether this grant is going to maintain as government policy. And my Lord, the third reason is that we know what policy position of government is, because they have told us in formal settings repeatedly. President, the department officials, and even the Minister of Finance, they have told us that grants is to be retained, strengthened, and extended, increased incrementally. So I can provide some references to those statements. Mention it. Once we would highlight more. President Sola. That's the second reason, my Lord. Yes. So the grant is permanent. There's a legal fixture. My Lord, nothing is permanent, and perhaps permanent is the wrong comparator. It's about it, and the respondents pit the two against each other, the temporary or permanent. It is that it is to be maintained indefinitely. It is to be extended, improved incrementally. The Minister, the President, and the DSD officials have all said so repeatedly. In those comments, my Lord, they also speak to basic income support. And we don't want to put this higher than what they have said. There's a policy direction that government appears to be moving in towards basic income support, but there's no formal decision, there's no alternative that has been implemented. What they have said is indeed, my Lord, they're not, but we don't rely on them as law. We don't rely on them to interpret the regulations. We rely on them to set the factual scene, my Lord. Because if in another universe, my Lord, you had before you a statement from the Minister of Social Development saying Cabinet has decided to terminate this grant at the end of the current month or the end of the current year. But Lord, that would have a bearing on the remedies that your Lordship might grant. Because the remedies that we seek are structural. They're trying to fix the problem of the grant. And it may serve little purpose to fix something that is about to be replaced next week. But there is no evidence, Lord. There is no statement that they can point to on the papers, as against the 10-20 statements saying the SRD grant is being extended, to say we are going to replace it tomorrow or next week or at the end of the current financial year. Nothing. And my Lord, this temporary argument seems to, it was advanced forcefully in the Black Sash matter back in 2022. It seems to have just echoed through in the positions taken by the respondents, even though it no longer fits the facts or the legal nature of this grant. Lord, that's our position on the temporary question. If I may then, my Lord, deal with the positions of the respective respondents. And my Lord, the helpful place for me to take you is Annexure FA 37 for the founding affidavit. That is at 002310. Is your Lordship with me? This document 002-310, Annex FA37, is a briefing document from the Department of Social Development to the Minister, at the time then Honourable Minister Zulu. And my Lord, this briefing comes at the time in 2022 when the department is transitioning from the Disaster Management Act version of the grant to the one that we now have. So it's the briefing preceding that transition to the grant under the Social Assistance Act. And my Lord, this document is particularly instructive on the relative positions of the Department of Social Development, on one hand, and National Treasury on the other. National Treasury, in its papers, my Lord, makes the admission that there are differences between them on the policy question of the future of the SRD grant. Differences between not just us and them, but between National Treasury and DSD. Treasury makes that admission. And this document, the briefing to the Minister, really captures what those differences are and the extent of them. My Lord, I'll take your Lordship to page 002312, paragraph 2.3 of the briefing from the Department to the Minister. 312, paragraph 2.3. Paragraph 2.3, my Lord, it's headed, the Minister of Finance needs to concur with the regulations. My Lord, it then reads, currently we have regulations that the Minister of Social, paragraph 2.3, my Lord. Minister of Finance needs to concur with the regulations. And the department, reporting to their own minister, reports currently we have regulations that the minister, that would be Social Development, sent to the Minister of Finance in November 2021, to which we still have not received a response. Continues, my Lord, every effort will be made to engage with National Treasury on the regulations. However, this may not yield any results due to their unfavourable views towards the SRD grant. Referring to National Treasury's unfavourable views towards the SRD grant. It continues, my Lord, the National Treasury has made a number of unreasonable requests for conditions on this grant. We may run the risk that they may just withhold concurrence if we do not accede to these. The DG has written to the National Treasury explaining the difficulties and even the constitutional implications of some of the conditions they require. Continues, we may also need to consider publication of the regulations without the Minister of Finance's concurrence. The Lordship will recall that Minister of Finance's concurrence is legally required for the promulgation of regulations. Lord, so what we get from 2.3 is that National Treasury held an unfavourable views towards the SRD grant. National Treasury had made what Social Development considered reasonable requests for conditions, and that the DG of Social Development had explained difficulties and the constitutional implications of some of the conditions that the Treasury had requested. We would also, my Lord, refer to paragraph 2.5 of this briefing. That talks about the budget. This is on page 313. Where the department reporting to their minister report that the heading is an insufficient budget was allocated for the SRD grant. Continues, an amount of 44 billion was allocated for 10.5 million people. The letter was sent to National Treasury, indicated that we would require a budget of between 56 and 75 billion per year for the extension of the SRD grant. We're already at 10.5 million that should be beneficiaries in January and likely to pass the 10.5 million mark in February. This is a 2022, my lord. So, my lord, this next part of the briefing reflects that DSD was seeking a larger budget allocation and that National Treasury had granted an allocation insufficient in the view of DSD. My lord, I'll deal with this issue in more detail later, but pause to note that that budget of 44 billion, that was the budget at the time. That budget has been slashed significantly since then. The budget at the time was 44 billion. This was 2022 now. My lord, largely done with this document, but there are two other aspects that we refer to. 2.5.5, my lord. This just repeats, it's the same figures that taken your lordship to earlier in a DSD parliamentary committee briefing. But here the department is saying to the minister, there are 13.4 million people in this age cohort with no income and 18.3 million people under the food poverty line, the current means test we are using. So it's the department, they're consistent, my lord, they said the same thing to the parliamentary committee. To their minister, they're saying, on the data that we have available, there are 18.3 million people in the country who would qualify for the grant. My lord, the final aspect of, actually two last aspects of this document that we would mention, paragraph 2.75 at 002-315. My lord, in 2.7.5. Yes, my lord. And my lord, this 2.7.5 refers to the agency, SASSA's lack of resources to make improvements to the administration system, and that ideally the agency should be introducing further administrative processes to reduce the high exclusions and inclusion errors on this grant. However, this will be constrained without any additional funding. So they're saying to the minister, my lord, SASSA ideally would be fixing these administrative processes, but they say it would require additional resources to do so. My lord, in 2.7.6, the department records there may be a general societal dissatisfaction due to the regulations not making any progress in terms of the calls for a higher value for the grant and ensuring less people are excluded. Lord, that paragraph is really showing the department is aware of the concerns being raised by, among others, the applicants and others in society about the lack of progressive realization, the stagnation of the grant, and the high exclusions. And it concludes, my lord, 2.77, from the allocation, no room is provided to reach more people or increase the value of the grant. So the department is saying we're being constrained by Treasury's allocation. But there are two further aspects I'll mention of this document just while I'm on it, where they relate to discrete issues. The next one, my lord, is at 002-316, para 3.5.3. 316. My lord, this is dealing with the meaning of the terms income and financial support. And it's explaining that the department added the term financial support, 5.3, added it to the regulations, wasn't there previously. Financial support is added to include, I beg your pardon, my lord, page 316 and paragraph 3.5.3. And my Lord, what the department reports to the minister is that financial support is added to include, quote, money obtained for any purposes, and thereby facilitate a relatively blunt instrument, such as checking bank account details. Well, that statement is relevant to the bank verification challenge and to the meaning of financial support, both of which we challenge. But the department is there explaining that financial support will include money obtained for any purposes, and that this is to facilitate the blunt instrument of bank verification. Well, those are the main aspects of that document. So if I may then return to the submission that arises from main point that arises, which is, what is the court to make of these differences between National Treasury and DST, the stances that they have taken in the application? What is the appropriate role of National Treasury in particular in this matter? What is its appropriate constitutional role? And my Lord, we make the submission that Treasury at times purports to speak for government as a whole in its papers. There are points at which it says, can't do that. Our expertise is in relation to financial, economic matters. And they do acknowledge that there are differences between themselves and DST. But my Lord, at various points, they do purport to say, this is government policy. This is the approach. And my Lord, we submit that is inappropriate for two reasons, my Lord. One is a general reason, which relates to Treasury's appropriate constitutional role. And the second is a fact-specific reason relating to the SRD grant. The general reason is this, my Lord, and it's perhaps best illustrated by an analogy. If we were in a case concerning the delivery of housing, or the provision of healthcare, medication, supplies of hospitals, the appointment of nurses, the delivery of education infrastructure, whether pit latrines at rural schools need to be replaced, and is what the extent of government obligations are. My Lord, we would not in such a matter accept that Treasury has a role to speak to the substantive issues, the substantive policy on what housing delivery should look like, on what healthcare should look like, on what education delivery should look like. Treasury has, my Lord, a vital role in our constitutional dispensation, relating to resource revenue generation and allocation, as well as setting norms around expenditure. But none of that, my Lord, goes to the setting of substantive policy, the areas of functioning of our government. And my Lord, is there any reason why this ought to be different with social grants? It is so that the social grant, unlike housing, healthcare, or the education, takes a cash form. And it is so that that means that consideration needs to be given to affordability. We accept those, my Lord. But the substantive policy on social assistance for the country, what that should look like, how Section 27 of the Constitution is to be realized, that function does not lie with Treasury, my Lord. It lies primarily with social development. Yes, together with other relevant government departments and functionaries. That's the general reason, my Lord. Treasury, we submit with respect, is in certain areas overstepping role in its opposition in this matter. My Lord, there's a bit of a back and forth in their papers in this respect. At certain points, they list a series of prayers which they say these are beyond us, these are in the expertise of the department and SASA, but they then do go on to address them, my Lord, and to oppose them, primarily on affordability grounds, but not exclusively on affordability. So, my Lord, that's the first part. But, my Lord, the second reason why caution has to be applied in having regard to Treasury's substantive positions, my Lord, is because, as we've seen in FA 37, Treasury is at odds with the DSD and has unfavourable views of the SRD grant, as reported to the Minister of Social Development. To be very clear, we did not oppose Treasury's intervention. We accept that they have an important role to play in this matter, providing information to this court on available resources and questions of affordability. But the future of the SRD grant, policy position of government, my Lord, those are not matters that fall within me. It has to consult Treasury on the value of the grant, my Lord. And my Lord, in that respect, there is another somewhat disturbing aspect of the answering affidavit of DSD. That is, my Lord, the statement which is certainly legally wrong. But they say, my Lord, that National Treasury was solely responsible for taking the decision on the grant value. In other words, National Treasury alone decided that the grant value should be 350 rand. Regulations, my Lord, are promulgated by the Minister of Social Development, requiring the concurrence of Treasury. But what DSD tells us is that National Treasury effectively usurped the Minister of Social Development's role and decided the grant value. Lord, that on its own would be a sufficient basis to set aside the grant value, because National Treasury doesn't have the power to make that decision. But what it also shows, my Lord, is that there are dynamics at play as between the organs of state that are not in line with constitutional roles of those organs of state, my Lord. And ultimately, my Lord, we would expect DSD and SASSA to be at the forefront, engaging around the issues of the grant, identifying ways to fix the problems with the grant. Data that can support to find those solutions. We have called on them to play that constructive role in this matter. The decision-making power lies with the Minister of Social Development. That decision requires the concurrence, the agreement of national, the Minister of Finance. So the power is exercised by the under Section 32 of the Social Assistance Act, promulgated by the Minister of Social Development. She promulgates the whole set of regulations with the concurrence. Well, my Lord, well, my Lord, we do. So that was at a particular point in time, 2022, the birth of the current regulations. We do know that the Minister of Finance gave his concurrence ultimately. It's also admitted, confirmed by Treasury in their papers, that Treasury did insist on a number of the conditions that were added to the regulations, which appear to be the regulations that the DG of Social Development had constitutional concerns about. So it appears, my Lord, that they reached a compromise, they reached agreement. The question for this court, my Lord, is whether compromise is consistent with the Constitution, and we submit that it is not. My Lord, turn now to deal with the legal framework. And we've dealt with it in some detail in our heads of argument. Don't intend to repeat that, but just to highlight what we say are the key principles and structures that govern the tests that your Lordship must apply. And my Lord, it appears to us that there is no difference between the parties on the application of the three causes of action that we rely on. They apply, whether we meet those tests is in dispute. But it's the right to social assistance, primarily, Section 27 of the Constitution. Haja, so administrative justice review, different grounds for the different challenges. And finally, the principle of legality of Haja doesn't apply. We don't understand the respondents to contest the application of those legal principles. They depart from us on the conclusions. And my Lord, the key principles in relation to the right to social assistance, which we've developed in our heads of argument, articulate the reasonableness test, which was developed through the jurisprudence, most notably from the Grootboom decision, treatment action campaign, Mazibuko in particular. We've included those cases, my Lord, in the abridged bundle of authorities that we provide. My Lord, there are certain key principles that we would emphasize that emerge from those authorities. My Lord, we're now at a point in our jurisprudence where we don't need to waste any time on the justiciability of the rights. That is clear, and the test is clear. Overall, a test of reasonableness under Section 27 in relation to social assistance. My Lord, we submit that the starting point is understanding the purpose of the right to social assistance. And the key authority on that, my Lord, is judgment of the Constitutional Court in Xhosa, and the unanimous judgment of Justice Mokoro, where, my Lord, Justice Mokoro held as follows at paragraph 52. My Lord, I can take you to it in our bundle. It's at page 102 in our bundle, the blue file, my Lord. 102 of our pagination. And it's paragraph 52, my Lord, under the heading, the purpose of providing access to social security to those in need. My Lord, Xhosa was an early judgment of this court. It was the first judgment that engaged seriously with the right of social assistance. So the court was really setting out the fundamental principles. And paragraph 52, my Lord, Justice Mokoro held as follows. The right of access to social security, including social assistance, for those unable to support themselves and their dependents, is entrenched because as a society, we value human beings and want to ensure that people are afforded their basic needs. Society must seek to ensure that the basic necessities of life are accessible to all, if it is to be a society in which human dignity, freedom, and equality are foundational. Lord, we submit that dictum really captures the purpose of the right to social assistance in our Constitution. It is about dignity. It is about providing for those who are, in the language of the right, unable to support themselves, to ensure that all such people, my Lord, have the basic necessities of life. And my Lord, if I can take you then just up the page, that's the purpose of the right, but how then does reasonableness apply in the context of social assistance? Paragraph 49, where Justice Mokoro holds that in dealing with the issue of reasonableness, context is all important. She goes on, my Lord, to explain that we're dealing with the exclusion of a category of persons. There it was permanent residents who had been excluded from a particular grant scheme. The court ultimately upheld that challenge and held that it was a violation of Section 27 that could not be justified under Section 36, that permanent residents were excluded from the social assistance scheme. Lord, we then draw guidance in dealing with the reasonableness test from those later judgments, separate judgments of Grootboom, Mazibuko Treatment Action Campaign. We've extracted what we submit are the key principles and put them in our heads, but we will highlight certain features, my Lord. The first, my Lord, first, my Lord, and perhaps this is the appropriate starting point, particularly given the stance of the respondents. We accept that reasonableness is a range and that it entails a measure of deference to government, and that there is a range of reasonable measures that can be taken by government that would pass constitutional muster, that it is neither for litigants nor a court necessarily to determine the best measure that can realize rights. It is a range, but that doesn't mean, my Lord, that reasonableness is a blank slate for an unchecked standard that is effectively whatever government adopts is reasonable. There are certain requirements that still need to be met, my Lord. And these include, crucially, my Lord, that where there are unreasonable limitations or exclusions from access to a right, that would be unreasonable. Lord, this has arisen in a range of cases, from a Grootboom, where it was the unreasonable exclusion of the most vulnerable in need of desperate need of housing. The principle was endorsed in Mazibuko. It was also endorsed again, my Lord, in the Constitutional Court's Blue Moonlight judgment, where it was about the exclusion of occupiers living in privately owned property. The core principle, my Lord, is if there are unreasonable limitations or exclusions, that will render regulation, a law, a measure inconsistent with the Constitution. The second key principle, my Lord, that we would emphasize, and we do so in particular in response to the Department of Social Development, is this, and we set it out at paragraph 52.3 of our heads. It is that even if a measure is capable of achieving a statistical advance in the realization of the right, it will not pass muster if it fails to respond to the needs of those most desperate. And my Lord, this principle was held in Grootboom at paragraph 44. In our heads, my Lord, it's paragraph 52.3. These principles are really summarized in paragraph 52 of our heads, my Lord, the core principles around reasonableness. I'm simply highlighting some of them. This is from Grootboom, paragraph 44. My Lord, the point is this: a statistical advance is not good enough. It is not good enough to say, but we have given the grant to many millions of people, and therefore it's a reasonable measure. If in the course of doing so, many millions more have been unreasonably excluded, that's the principle and how it applies here. A statistical advance is not enough to say that we've given it to a number of people. If it fails to respond, especially to the needs of the most desperate. The third principle that we would emphasize, my Lord, is the need to be adaptive to changing circumstances. Lord, this principle is articulated in Grootboom at paragraph 43. It is also applied quite significantly in Mazibuko at paragraph 162 of Mazibuko. And this is the principle, my Lord. I'm with you, my Lord. So the Grootboom reference, my Lord, paragraph 44, and it appears in our authorities under The individual cases are uploaded on Caselines, my lord, so I can give you both references. And the curriculum reference, my lord, is page 80 of our authorities bundle, this abridged hard copy. And the Caselines reference is 021-684. And Mazibuko, it is page 136 of our bundle, the abridged bundle. Paragraph 162 of the Mazibuko judgment. Baseline 021-895. Indeed, so, my lord. The Mazibuko dictum really captures the principle very effectively. In many ways, it was decisive in that case. My learned friend is very familiar with it and helped to establish the principle, my learned friend, Mr. Marcus. And, my lord, this is the principle, paragraph 162, Justice O'Regan's judgment. Not only must government show that the policy it has selected is reasonable, it must show that the policy is being reconsidered and consistent with the obligation to progressively realize social and economic rights in mind. Policy that is set in stone, never revisited, is unlikely to be a policy that will result in the progressive realization of rights, consistently with the obligations imposed by the social and economic rights in our Constitution. So, principle, my lord, is that government may adopt a policy which may even be reasonable at the time, but it cannot be rigid and set in stone. It has to have regard to the impact of that policy. Is it working? We've submitted that the system here is broken, it's not working. In Mazibuko, my lord, that principle was ultimately decisive. The court held that the city of Johannesburg had indeed responded positively by making a number of amendments to its water policies during the course of the litigation that dealt with issues of exclusions and access. The court ultimately held that, although that had been a moving target during the litigation, the organ of state concerned was to be commended for doing so, for being responsive and identifying ways to fix the system. That is the next key principle that we emphasize in relation to reasonableness. My lord, the final principle that we would emphasize, and it now goes to progressive realization, because that's the other aspect of the requirement. And it really links to what I've just, principle I've just articulated, that policy can't be set in stone. Progressive realization, my lord, requires the state to move incrementally towards the full realization of rights. The Constitution recognizes that full realization cannot be achieved immediately. But what is required of the state is to identify what would full realization look like. In this case, what grant value would fully realize the right, and then to adopt a reasonable plan to move towards full realization. And my lord, it's in this respect that I also need to go to the other side of the coin of progressive realization, retrogression. We've submitted that in relation to the grant value and the means threshold, there has been a retrogressive measure by government, in that the real value of both of those amounts has decreased in time because they were allowed to stagnate. My lord, I'm here giving you the legal basis. The non-retrogression principle was endorsed in Factual at paragraph 45. Lord, that is page 80 of our bundle of authorities. Zero two one six eight four. And then, my lord, in Mazibuko, at footnote 17, my lord, of the Mazibuko judgment. And my lord, that appears I beg your pardon, my lord, it's actually footnote 31, Mazibuko. It appears at 021897. Lord, we have there in Furkum and Mazibuko the Constitutional Court endorsing the principle that relating to non-retrogression. In doing so, my lord, both decisions, the Constitutional Court referred to the international law, endorsed the international law on non-retrogression. My lord, the relevant international law authority, which is quoted in full in that Mazibuko footnote, is General Comment 3 of the Committee on Economic, Social and Cultural Rights. And the relevant sentence, my lord, is, moreover, any deliberately retrogressive measures in that regard would require the most careful consideration and would need to be fully justified by reference to the totality of the rights provided for in the covenant and in the context of the full use of the maximum available resources. My lord, this is an appropriate segue for me to deal very briefly with the international law. And all we intend to do here, my lord, is to identify what the two key sources are and three key principles. And I'll say at the outset, my lord, that this international law fits perfectly well with our own constitutional scheme. And given that these are binding international instruments, my lord, the international law is to be followed. They've been ratified by South Africa, is to be followed unless it's fundamentally inconsistent with our constitutional scheme, which it is not. Lord, we deal with the international law in some detail in our heads. I don't intend to repeat. There are two instruments. The International Covenant on Economic, Social and Cultural Rights, which was adopted in 1966. It came into force in 76, but crucially, my lord, it was ratified by South Africa in 2015. And my lord, that is important because several of the cases that our learned friends rely on were pre-2015 cases. We submit that, and even in those cases, the covenant was referred to. At that point, it was a persuasive authority. It was non-binding international law. But since 2015, it has been binding on South Africa. So the approach, South Africa's obligations under that covenant ought to be followed, unless there's some fundamental incompatibility with that constitution. And there is not. The second instrument, my lord, is the African Charter on Human and People's Rights. And under both instruments, my lord, there are subsidiary authorities that have interpreted the right to social assistance under this treaty. In relation to the covenant, at TESCA, it is the general comments and two cases, communications to the committee against in the Trujillo Calero versus Ecuador, and a second case, but Calero is the main one, as well as so those are the international covenant ones. Trying not to get too bogged down in the detail, my lord. In the African Charter, there's one key instrument that interprets the Charter. That is the African Guidelines and Principles on Economic, Social and Cultural Rights, which was adopted by the African Commission. My lord, we've drawn on those sources to distill the following three key principles. The first, my lord, perfect fit for our system is that the test is reasonableness. So the international authorities adopt the same test. The second principle that we'd emphasize, my lord, is the non-retrogression principle. What comes from the international law, my lord, is where there is factually a retrogression, doesn't mean that it can never be justified. but what follows is that there is a presumption of a violation of the right and a higher threshold for justification. If the state has taken backward steps, there's a presumption of a violation, a higher threshold to non-replication. And the third principle, my lord, which comes through strongly from both international regimes, is this duty on the state to constantly review. As the Mazibu court said, the approach cannot be set in stone. If as you apply it, as you apply the policies and discover that people are being excluded, there are problems, duty is to fix them by constantly reviewing the success, the operations of the system. My lord, those are the legal principles on which we primarily rely. I can then turn, my lord, to the specific challenges. My lord, I've indicated that I will be dealing with the challenges to the regulations, and my learned friend will be dealing with the implementation problems on payment. Challenges to the regulations fall in two categories. The first are the exclusion barriers. So that includes the online-only application process, the overly broad interpretation of income and financial support, as definitions. Third, the unlawful questions in the online application form. Fourth, the challenge to bank and database verification. Fifth, narrow appeal process, appeal challenge. And sixth, the budget cap in the regulations. It says that once the allocated budget is spent, SASSA cannot pay any other qualifying beneficiaries. So those are the six challenges in that first category, my lord. The second category relates to the grant value, the means threshold. So, I'll begin then with the online only application. Well, this challenge is directed to Regulation 3.2, sub 2, which provides that an application for the SRD grant must be lodged on the electronic platform. Previously, my lord, in earlier iterations of the regulations, grant could be applied for electronically, but also, quote, over and above any other available means of lodging such applications. The online restriction was added in to the current version of the regulations. And my lord, we've made the observation that this sets the SRD grant apart from all of the other social grants that SASSA administers. It's the only one where the only way you can apply is online. All of the other grants, applicants can either apply online if that's available, or they can go to a SASSA office and apply in person. And my lord, it's important for me here to clarify the nature of our case, because it appears that there was some misunderstanding from DSD, particularly initially in the answering papers. We do not seek to do away with the online process. We accept everything that they say about its benefits, its reach, for those who have been able to use it. The point of our attack here, my lord, is the restriction to online only. And it's our submission that it's that falls to be set aside, and that there is no justification for barring SRD applicants, those who need to do it, from applying in person, my lord. We have the questionnaire. To take an instruction on attaching documents, but it's I can take your lordship to the form, and I'll deal with it in a moment when we deal with the questions that we challenge. We challenge 2 of the questions on the form. But you basically populate, you enter text on the online system. We have tried to print that. I'll take an instruction on whether you can attach anything. My understanding is that that is not possible. Certainly, later problem is on appeal, you're barred by the regulations from putting up any information. My learned juniors both confirm that no attachments are possible. So it's really entering text on the form. Online. No attachments. No. Enter your ID number and other personal details. And Lord, I can give you the reference to the form. It is FA61 at 002-455. Lord, I will take you -455. 45555. My lord, it begins with mobile number. It's got a number of fields: mobile, ID number, full name, surname, and so on. Address, a cell number where you can receive things. It is FA61 indeed, my lord. And in a moment, I'll come to, on the 3rd page of it, there are 2 particular questions that we challenge as being ultra various and unlawful. The online form, my lord, it's an interesting creature perhaps in law, but we would submit that it's a form of delegated legislation, subordinate to the regulations themselves. Regulations provide for this online electronic platform. This is, the department has produced it. The point I was seeking to make, my lord, is that we do not seek to reverse the advance into the digital age. We see the benefits in terms of efficiency, access. The problem is the people who are excluded, my lord. And the evidence confirms that those are not marginal exclusions. The reasons for those exclusions are clear, my lord. They include lack of access to digital technology, limited internet connectivity, and lack of digital literacy. Lord, the evidence that we've put up in that regard does not seem to be seriously disputed by any of the respondents. Save for DSD. DSD, my lord, acknowledges that there is a problem of lack of smartphone access, but in its papers, effectively denies that there are exclusions happening. Lord, we put up 2, the evidence that we put up in this regard, Lord, includes published reports on internet and digital access in South Africa, statements by DSD itself, then 2 sets of individual accounts, my lord, problems individual people have experienced. That's in 2 places, my lord. The first is a set of tweets on the department's Twitter account. So these are responses from members of the public, tweets from members of the public. Lord, I would with respect refer to some of them to give an indication of the problems that people experience. So these particular tweets are attached as Annexure FA66. At 002-491. Look, we accept, of course, that these are tweets, public tweets. We don't have confirmatory affidavits from these people. We have separate affidavit evidence. These are public tweets. we're not able to identify the people specifically necessary. But these are what members of the public have posted on the official SASSA Twitter handle. Starting with the first one on 002491, where Janice Pillay posted in August 2021. Official SASSA, why isn't the status site not working until now? I would like to know whether I'm approved or still pending 350, hashtag 350. Then there is a tweet from Maflatse. I tried to register for 350 unemployment relief fund, but I don't get an option of South Africa. Please help SASSA. Someone seemingly identifying technical problems. The next one over the page, my lord, from someone called Kensani Raymond. At official SASSA, your page never works. Nati, the chatbot loses her mind halfway through, and next you'll be telling us 350 Rand have been chowed. Nothing works, including the inquiry email and call center. The language is often colloquial, my lord, given that these are tweets. The next one, my lord, at the foot of the page, from an account with the Twitter handle, The Great People of South Africa, tweets, at official SASSA, please kindly fix your online application system. It's broken and we could not submit any of the people we were assisting to apply to them. They are all in desperate need of this grant and your systems are failing them. And it tweets at Lindiwe Zulu 6, hashtag 350. In similar vein over the page, my lord, tweet from someone identified as activist. SASSA website not working since they opened the application for that 350 SASSA grant official. Later one at the foot of the page, asking at official SASSA server crashed, question mark. My lord, those were relatively early problems. Those tweets so far have been mainly from 2021. But the tweets over the page on 494 continue into 2022, around the time the application was launched, June 2022. Just mentioned, refer to some of them. There's a tweet from someone called Mike DeFlorio, tweets at official SASSA, the website is utter rubbish, it keeps timing out. Do you even care about this? Because it looks like you do not. Hashtag SASSA. The next one from a Kahiso, at SASSA, at Lindiwe Zulu, at Power FM, as we are trying to apply for the SRD grants, all your systems are not working. So I don't know what to do, please help. The next one by someone called Spiso Shange. This is an August 2021 tweet. Do you really expect poor unemployed people to apply for this grant in this complicated and expensive app? Are you people normal in your heads? I won't read the remainder of the tweet, which directs some somewhat derogatory comments at two political figures. The final tweet, my lord, from someone called Margaretha Steen, it appears to be. SASSA, your website has had this problem for a long time. Okay, we understand that it was down on Monday. I tried updating my banking details on Monday and I never received a message. 24 hours has passed, it's 36 hours, I still can't update. It goes on to 2 weeks. My lord, and I don't want to be misunderstood. Any online system is likely to experience technical difficulties from time to time, and that is likely to be an aspect of administering an online system. So we accept that those problems may arise. But the issues of access go deeper than the system falling down, the system crashing. They're about people not being able to use the online system at all. People who either don't have the technology, don't have the internet access, or don't have the digital literacy, aren't able to complete the form themselves online. And my lord, in this regard, certain of the supplementary affidavits that we have put up fall in this category. There are people who say, I experienced difficulties using the online system. And I'll give you just two for illustration, my lord. First is Ms. Malate, and the reference is 002 621. Well, this is a Miss Caroline Chikana Malate. Miss Malate, paragraph 4, page 622, talks about her general struggles to survive in life. But then says, I struggled greatly to come to a point of being able to apply for the social relief of distress grant. Initially, the process was unclear to me as someone who was not familiar with mobile technology beyond the basic calls and SMS functions. Then she talks later about being rejected, but that's when she does eventually apply. The second, my lord, is a Miss Hendricks. Her affidavit appears at 002658. Begins at 657, but the relevant paragraph is 658. This is Miss Mary Jane Hendricks. My lord, the relevant part of her affidavit states, it is difficult for me to apply and appeal online because I do not have the means to access the process online. That's paragraph 3, my lord, on page 658. Start on 658, paragraph 3, the sentence that begins, yes, indeed, after since 2014. It's difficult for me to apply and appeal on it. Lord, we not only have the evidence that says that in general, South Africa experiences problems of lack of access to online technology. We have the evidence afterwards of people saying they've struggled to use the online system. And Lord, we've got referred to the tweets and the supporting affidavits. There is further, my lord, the statement of Dr. Mbala, who's the chairperson of the Financial and Fiscal Commission. Lord, this is quoted at page 58, paragraph 121 of our heads. Where Dr. Mbala, the chairperson of the FFC, my lord, says the following about this online issue. 121, indeed, my lord, our heads. Lord, the quote there from the chairperson reads, the success of any intervention is dependent on how well it is implemented. The implementation context of the SRD grant largely assumes easy access to internet data for many applicants. Either applicants apply themselves or access another implementing agent, such as the post office, to facilitate the online application process. But she then continues, my lord, in instances where applicants lack the online application know-how, or struggle to access the post office network, especially in rural and outlying areas, those who are in dire need are ultimately excluded from accessing the SRD grant due to the imposed application conditions. My lord, notwithstanding this evidence of people struggling to access, some people struggling to access via the online system, PSD and SASA have taken the position that they refuse to implement that. But what they have done, my lord, and they reveal in their answering affidavit, is they say that they are currently piloting the use of self-help kiosks within their offices. Deal with that at paragraph 122 of our heads, my lord. So, my lord, it appears from that decision to pilot self-help kiosks that they've recognized the problem and they're starting to explore a solution to address it, but only on a pilot basis. only at certain offices, calling that every other grant can be applied for at every other SASSA office throughout the country. So, my Lord, what are the grounds on which the respondents oppose this relief? DSD and SASSA, my Lord, effectively throw into question whether there are people who are struggling to access, whether people who cannot access online using cell phones. Well, they do so without any evidence, effectively just a bald denial. They do so, my Lord, in the face of a study that we put up, that 2018 study, that shows that just 37% of lower income people in South Africa own a smartphone. Lord, DSD effectively says, well, people can share phones. The system allows that, up to 5 phones to be used. And they say the online system is easy. It's not time consuming. They say in their heads that applicants can apply from their comfortable homes. Lord, we submit that those submissions are quite out of touch with the realities of beneficiaries of the SRD grant. We submit, my Lord, that what is reasonably required of the department is to expand the hybrid procedure that it is piloting to ensure that people who cannot apply online are able to apply in person. And my Lord, we draw a parallel here to the Treatment Action Campaign case, where at that point, when the matter came to the Constitutional Court, government was piloting provision of nevirapine, but had stood firm against rolling it out more broadly. And the court had regard to the fact that government had already identified what was needed and begun to pilot. It had taken that initial policy step, but not followed through. And we submit that this is a similar issue with the online-only system. Lord, we submit that limiting SRD grant applicants to online-only applications violates the rights in Section 27, that limitation cannot be justified. It is a retrogressive measure too, my Lord, because previously the regulations allowed access in other forms. And it is unreasonable also in PAJA terms, my Lord. We submit that it falls to be set aside violating Section 27 and for violating the relevant grounds in PAJA. Lord, when we deal with remedy, there may be issues, practical issues around rolling out in-person applications, which I'll deal with when we come to the relief. We recognize that if your Lordship were to make this order today, measures would have to be put in place to enable SASSA to assist online in-person applicants. But we'll deal with that when we deal with the relief. And we would welcome in that regard what DSD and SASSA say they would need in order to do that, in terms of time, in terms of process, because they know best. Well, that's the first challenge. The second takes us to the definitions of income and financial support. If I may then turn to that issue. Lord, this arises from Regulation 2.1 of regulations, which introduces the means threshold. Regulation 2.1 provides that in order to qualify, a beneficiary must be a person with insufficient means. Regulation 1 in turn defines insufficient means to mean that a person is not in receipt of income or financial support. And the regulations then go on to set a prescribed threshold for income and financial support at 624 Rand. What all of that means, my lord, is that in a nutshell, there is a 624 Rand means test, and a person must have income and financial support below 624 Rand in a particular month in order to qualify. So this raises the question, my lord, in law of the meaning of these two terms, income and financial support. What do they mean? We know that as a matter of statutory interpretation, to begin with, they must have a meaning and that they must mean different things as an ordinary principle of statutory interpretation, income and financial support, both of which fall under this umbrella of insufficient means. So what then, my lord, is the approach, the interpretation that DSD and SASSA have advanced and that they implement? It is, my lord, an interpretation that effectively reduces both terms to meaning all money, any money. Income and financial support mean money, received for whatever purpose, on whatever basis, for whatever reason, even for another person. For any money, it's an unlimited definition. During the course of the proceedings, my lord, DSD and SASSA have made those two concessions, and National Treasury, I beg your pardon, have made two concessions in this regard. DSD and SASSA accept that child support grants should be excluded from income and financial support. So if a parent is applying and they're receiving into their account also child support grants, that shouldn't count towards the 624. The child support grant in any event would take any applicant above 624 because it's higher. The second concession, my lord, is about money held on behalf of another person. National Treasury accepts in principle that that ought not to be part of the meaning of these terms. But, my lord, that is not the state of play at present. What is currently being administered appears to be the any money approach through the bank verification system. And, my lord, we see this in particular from many of our supporting affidavits. And they speak to being excluded, significant number of them, reference them in our heads, because they received a child support grant. They then get rejected for having income or financial support above the threshold. And there are also examples, my lord, of individual applicants who are using their bank accounts to hold money for a sibling. There are two who say they did so on behalf of a sister who didn't have a bank account. And there is one individual, my lord, who was holding family money for their mother's funeral. And those are people who all get rejected for those different reasons. My lord, we have sought to identify constructive, sensible meanings for both of the terms that give different meaning to income and financial support, meaning that accords with the purpose of the right in Section 27, which is that the purpose is to provide social assistance to people unable to support themselves, and in particular to achieve the purpose of the SRD grant, which is to reach those people. And we submit that our interpretations do that. And they are the following, my lord. They're set out in our heads at pages 66 and 67, paragraph 137.4. 66, sorry, don't have a page 66 of our heads of argument. I'll leave it to you. 014-69, I'm indebted. Lord, we have, just to indicate that our relief in this respect is a primary relief and an alternative. Primary, my lord, invites the court to grant to issue a declarator saying this is what the terms mean. That will give guidance to SASSA and to beneficiaries and to everyone. It will clarify what the terms mean. The alternative relief is if, for whatever reason, the court were to conclude that it is not possible to give that declarator, to give those meanings to the terms, we seek an order of invalidity and a reading in of the same definitions. So either way, my lord, we get to the same destination, which is to suggest two possible definitions for the two terms. In relation to income, my lord, we propose a definition that it should mean money received on a regular basis from formal or informal employment, such as wages or earnings from informal trade, business activities, or investment. Lord, these definitions draw on dictionary definitions. They draw on what other legislation does. That term income in particular is used in several other laws. So that's what we've suggested. Regular basis. The essence of it is formal or informal employment. We're not saying only wage employment with an employment contract, informal trade and other informal employment also, plus business activities or investments. So that would be the meaning that we would propose for income. In relation to financial support, my lord, we propose a meaning that it is as follows: regular payments which benefit the recipient, that do not constitute income, and which the recipient has a legal right to receive. Lord, there are aspects of those definitions that it appears to us that the respondents agree with, and others that it appears to us they disagree with. It appears to us, my lord, that National Treasury accepts the part of the definition that includes which benefit the recipient. But they take issue, my lord, with the regular aspect and the legal right to receive. Lord, we submit that our definition of financial support would be a clear and workable one. It would include, for example, spousal maintenance, because someone receives that by virtue of a legal obligation regularly and for their own benefit, but it would exclude the child support grant because that is not received for one's own benefit. Lord, those are the definitions that we suggest. We have invited the respondents to propose draft order or language of their own, indicating where they agree and where they disagree on those elements, which we submit to be of assistance to the court. And if they do make such proposals, my lord, we will of course engage with their proposals. But what we have tried to do, my lord, is give sensible meanings to the two terms, so that they mean something that can then be clearly identified. It enables decision making. Well, there's one further aspect of this which really links to bank verification, which is that DSD and SASA say, well, bank verification is a blunt instrument, and all it can do is look at money as money. Well, Lord, I'll deal with that issue, of course, when I deal with bank verification. We submit that that's no answer to the legal question, what do these terms mean? They must mean something. That meaning must be determined by a court so that everyone knows what their rights are. The practicalities are a separate issue. What is practicable? How it can be implemented? Lord, I see that it is 1 p.m. I've included at least 2 of those regulation challenges. If your lordship considers it appropriate, be a convenient time for us to stop. My learned friend, Mr. Marcus, my lord, did raise with me again the question that your lordship raised in chambers, which is whether the lunch adjournment might appropriately be shortened. We have not reached the point that we had hoped to by this stage, my lord. Made some significant progress. We anticipate it being at least another hour, my lord. Indeed, perhaps closer to an hour and a half, my lord. Hour for me and an hour and a half, my lord. Hour for myself and half an hour for me.
I'm somewhat dismayed at the length that this has taken. Could I propose a practical arrangement? My learned friends are going to be another hour and a half. Really doesn't make too much sense for us to start today. I would suggest let them finish, perhaps taking the adjournment, and we will commence first thing in the morning. But we're entirely in your lordship's hands.
Would have no difficulty with that, my lord, and the shared objective is to conclude proceedings by the end of what day tomorrow. We're comfortable. We would then still do something. We don't envisage the reply being unduly extended. Lord, in light of my learned friend's suggestion, and we would suggest that it remains appropriate to take the full lunch adjournment, in your lordship's discretion. We would then ensure that we do conclude today, and no doubt tomorrow can be suitably allocated between the two respondents. We don't envisage anything more than My Lord, I had concluded our submissions in relation to the first two impugned regulations, the online-only requirement and the interpretation support. I turn now to a related question, which flows from that question of income and financial support. And my Lord, this challenge depends, in effect, if your Lordship is with us on income and financial support, or at least with us partially, then the second challenge to the questions in the questionnaire flows from that. If your Lordship were to find that those two terms legitimately mean any money received for whatever purpose whatsoever, then this next challenge doesn't really arise. But it's best understood, my Lord, if I take your Lordship to the questionnaire itself. And my Lord, the offending questions appear on page 457. If your Lordship is there. And my Lord, before I turn to the offending questions, let me point to two questions that already serve the purpose of the questionnaire. Our submission is that there are questions there that already elicit the information on income and financial support. And then the problematic questions are the ones that go further and trap applicants, resulting in false rejections. The two legitimate questions, my Lord, are the second question on page 457, which reads, are you currently performing any work for which you are paid more than 624 Rand per month? And my Lord, that question covers the core of the income inquiry. Are you performing any work? That work could be formal or informal, for which you are paid more than 624 Rand per month. That covers most of our definition of income. And then in relation to financial support, my Lord, if you skip 4 questions, you will see your Lordship will see the question that reads, do you receive financial support from a relative, friend, or any other person of more than 624 Rand per month? So we submit that financial support is also covered. The information will be acquired in that way, and people will be granted or refused appropriately. The two problem questions, my Lord, arise immediately above that question. And the first one is the question, how do you usually obtain your basic necessities on a monthly basis, or where do you get money to support yourself if there is no 350 Rand grant? And my Lord, we submit that this is probably the more egregious of the two questions, because what this question asks an applicant is, if you do not have the 350 Rand grant, how do you survive in the month? What else do you get? And it then offers a series of drop downs: paid employment, casual work, a family in the household supports me, a family member outside the household supports me, or a friend in the household supports me. My Lord, each of those questions, those possible answers, would exclude an applicant. There is no option that allows them to say, well, I can't survive, I starve. And so the difficulty with that question is that it traps an applicant, if they respond to the question, into an answer that will exclude them. That's the first problematic question. The second is the one that follows upon it. And that question reads, how much money did you receive in the last month, including gifts, assistance from anyone, donations, dividends, earnings from formal or informal employment, but excluding the 350 Rand grant? Our challenge to that question is partial, my Lord. We accept that dividends and earnings from formal or informal employment are permissible. Those are part of income and properly understood. But gifts, assistance from anyone, donations, we submit, properly understood, do not constitute income or financial support. My Lord, the reason why this is so significant is because the data shows that 25% of rejections, those several million rejections each month, a quarter of them are due to self-exclusionary responses on the online form. So 25% of people who are rejected found the online form and submitted, even submit in good faith as the ordinary applicant. They qualify. A quarter of them end up excluding themselves with their responses. And we submit that the problem questions are likely to be the two that we've identified, and we've identified the extent to which those questions are problematic. We submit that if those two questions were removed, or in the case of the second question, tailored, reduced down so that it only dealt with the permissible parts, the questionnaire would serve its purpose lawfully, adequately. So it's quite a minor fix, my Lord. A couple of questions on the form, but it affects 25% of several million rejected applicants, in excess of perhaps 1 million people each month are excluding themselves as a result of the questionnaire. So we submit, my Lord, that those two specific questions are unlawful and fall to be set aside. And we do so on two main grounds. The first, my Lord, is that they are ultra vires, those two questions, because the scheme of the regulations is that an applicant qualifies subject to income and financial support. The two questions go beyond income and financial support, and so they're ultra vires, the regulations. They exclude people based on money that is not income or financial support. And the second ground, my Lord, is that those two questions have the effect of SASSA taking into account irrelevant considerations. So it's that PAJA ground. Questions lead to the decision maker taking into account irrelevant considerations. Ultimately, though, a relatively straightforward fix, my Lord, to remove or rephrase those questions. The rest of the questionnaire actually functions without them. So to demonstrate, it captures the information relating to income and financial support in the other questions already. Well, the next issue relates to bank and database verification. My Lord, there are really three difficulties with this method. The first is independent problems with bank verification and database verification. So problems that apply specifically to that method. And the third, my lord, is that there's no conflict resolution mechanism to determine how you apply the multiple different methods together as a decision maker. But each is problematic on its own, and then there's the problem of how to apply them collectively. My lord, if I deal first then with database verification. And again, the scale of the problem, the impact of the databases is significant. Both Treasury and DSD admit in various places that there are errors in the databases. My lord, the scale of those errors is what is significant, and we would take your lordship to FA 71, which is at 002-522. 522. The document, in fact, begins on the preceding page, 521. Relevant page is 522 that we'll take you to. My lord, this is a report prepared in late October by Saldru and, in fact, the National Treasury's own Health and Social Development team. So it comes from Saldru and the National Treasury Health and Development team. And it's a report on social policy options. It really covers the SRD and alternatives to it. This is the relevant part of the report, at page 522. Foot of the page, the final bullet point. Reads as follows, my lord. Current SRD implementation highlights results of lower feasibility, large exclusion errors. And it continues, discussions with the SRD officials reveal employment data. My lord? My lord, we're on 002-522. It should be should read efficiency versus implementation. And then the final bullet point on the left in that left-hand column. Beginning current SRD implementation. Text is rather small, unfortunately. Current SRD implementation highlights results of lower feasibility, large exclusion errors. And this is the crucial part, my lord. Continues, discussions with SRD officials reveal employment data used are 1 to 2 years old. With high labor market churn, this suggests a 35% false rejection rate. In the current SRD, suggests 4.5 million out of 13 million truly eligible claimants are falsely rejected, potentially accounting for almost all current rejections. Perhaps I should have started here that the database verification employs a range of databases, quite an extensive range of databases. But they include in particular the UIF database, SARS, NESPAS, government pension database, database of people who are serving, who are in custody. So there's series. What has been reflected in this research report by Saldru and National Treasury is that it's the labor data, so in particular the UIF database, that's significantly out of date, and that's resulting in significant exclusions. As many as high a rate of 35% mistaken rejections, wrong rejections, and that this could affect 4.5 million people. This research report suggests that the majority of the rejections may be due to that database, the labour database, which would be primarily the UIF database, possibly alongside the SARS database. And my lord, provide one further reference where DSD acknowledges the errors and their significance. That is at 002441. The date, my lord. The date is October 2021. The date of that report. There are indications in other DSD documents that this issue of the UIF and other databases being out of date was a concern and that they were looking to address it. But what is not apparent from the record is a report that the issue has now been satisfactorily addressed, that it's no longer a problem. And your lordship will have seen that a significant number of the supporting affidavits among the 80 individuals report that they were excluded because of one of the databases. So several of them refer to the UIF database. They say, I'm not employed, I'm not receiving UIF funding, but I was rejected because I appear on that database. Others refer to the NSFAS database, say I apparently appeared on that. I did try to register as a student, but in the end I didn't, and I didn't receive any NSFAS funding, but I was rejected. So those are the individual examples that fill in the picture. My lord, at 002441, this document, my lord, is a briefing by SASA. This is much more recent, May 2023. The document is FA60. Begins at 002429. Briefing by SASA to the Provincial Standing Committee on Social Development. The relevant page is 441. And it's simply that first bullet point, my lord, which reads inclusion and exclusion errors. These are largely as a result of inaccurate databases or timing challenges with databases such as the SARS database, NSFAS, and UIF. So SASA in that report to the Provincial Standing Committee identifies those three databases among all of them. To be clear on our challenge, again, the applicants don't have an in-principle difficulty with the use of technology, the use of databases. The problem is that the exclusion errors reach unreasonable proportions. If there's a 35% false rejection rate and such significant numbers of people are being falsely rejected, that renders the method unreasonable. And it requires concerted effort by the department to resolve the issues. That is the remedy that we'll get to in due course. But we submit that that level of exclusion error far exceeds what is a reasonable or acceptable, if any errors are reasonable and acceptable. Indeed, my lord, that is the argument advanced in particular on the part of DSD and SASA. They seek to make the problem of the unreliable databases the problem of beneficiaries and say that it's for them to have ensured that all of their data is up to date on all of these quite impenetrable government databases, my lord. We submit that that's an unreasonable expectation. And that in any event, my lord, if part of the answer to the database problem is to involve beneficiaries in some way, then that should be part of the plan that DSD and SASA develop pursuant to the court order. In other words, my lord, it's not enough for them to sit supine and do nothing and say, well, these millions of beneficiaries haven't contacted UIF or SARS or NESFAS. It's aggravated, of course, by the appeal difficulty, my lord, but here we're just dealing with the databases themselves. And we submit that what's required of them is to come up with a plan that addresses this high exclusion. Just by way of example, my lord, that plan might include, for example, mass SMSs to grant beneficiaries, telling them this is how you update on UIF, something of that sort. But what the department and SASA with respect cannot do is sit back, reject wrongly millions of people, and then say it's their problem, it's their fault, it's their responsibility. My lord, turn then to the issue of the bank verification. The issue here is somewhat different. Problems with the bank verification. So the first difficulty, my lord, is that the bank verification is fundamentally a blunt instrument. It treats any money that enters a person's account as income or financial support. And so as soon as more than 624 Rand enters your account, you automatically get rejected in that month. So it links to our earlier submissions on income and financial support. But there are further difficulties with the bank verification. One of them, my lord, is that it double counts income within one household. So the application for the SRD grant is individual. You apply as a person, and if there are 3 of you in your household, perhaps 2 parents and an adult child, we all meet to the means threshold. Each of you can apply independently. The difficulty is that if in that household, let's say that one member of the household transfers money which has entered their account to the other member, that money is counted twice by the bank verification system. Rather than being counted just in the account of the person for whose benefit the money is received. So that's the second difficulty, my lord. It's that double counting problem. And it's not hypothetical or abstract, my lord. We would submit that it is reasonable to expect that in most households, members of the household transfer money to one another in that way. It's your turn to buy the groceries, pay for the medical bills, whatever it may be. So that's the double counting problem. The third problem, my lord, is that there is no accounting for fluctuations in income and financial support. It's just a snapshot in one moment, that month, and it doesn't take into account that over a period of 6 months, say, the applicant is earning far below. In fact, that may be the only income they receive during that 6-month period, but it will mean that in that month they get nothing. But that is the scheme. That appears to be the design of the scheme. My lords, what then are the defenses in relation to bank verification? It really boils down to this. Your lordship saw it referred to as a blunt instrument when the officials were reporting to their own minister. Bank verification is a blunt instrument, and DSD and SASA effectively argue that it has been effective, sufficient. It allows them to take multiple decisions instantly through the use of technology, and that renders it successful. But, my lord, we submit that on its own is not the inquiry. The question is, if there is this automated decision-making, effectively AI performing the human function, those decisions are still required to be lawful. They're still required to comply with the regulations. And efficiency on its own is not a basis to justify the system. to be very clear again, my lord, our opposition is not to the use of technology such as bank verification in principle. It's that the errors are too high. It's that the system is just too blunt an instrument. And so in the course of its remedy, the plan that the department and SASSA we submit ought to be ordered to develop to fix this system, it would be about developing technological responses if they are possible, alternatively looking at other options, such as what your lordship raised earlier in question, whether it's possible to attach documentation. So, for example, my lord, if I'm a grant beneficiary and I know that this month I received into my account 800 Rand, which was to pay for a relative's funeral, or I was holding it for my sister to pay for her child's school fees, I would be, or it's a loan that doesn't constitute income or financial support, I would be able to attach a short document saying, I know I've received this money in my bank account this month, but please don't exclude me just on that basis. I have a reasonable explanation for it in this one page. And it requires then a human element, my lord. It does require a human element in the decision making. But that would be one possible fix. And ultimately, DSD and SASSA have the experience, the expertise of managing similar application processes at similar scale for all of the other grants. My lord, those are done manually, in person at the offices, with forms that people sign and fill in, with supporting documentation, with affidavits if necessary. So the DSD and SASSA would not be required to reinvent the wheel or come up with something new. They have systems that work for all the other grants. These technological approaches are not used for the other grants. They're, in a sense, piloting them on the SRD grant. And that's fine, provided that they reach a reasonable level of accuracy and don't have these mass exclusion rates. My lord, those are the challenges independently with the database and bank verification. The third aspect relates to the combination, because what the regulation does, my lord, is to list a series of methods, including bank verification and database verification, that can be used, but it offers no guidance to the decision maker on what to do if these conflict or which one is decisive. We are told in the affidavit of the department and SASSA that in practice bank verification is used as the decisive one, but that nowhere appears in the regulations. So on what basis are they doing that? How is an applicant to know that? How is an applicant to challenge such a decision? It's about an absence of clarity in the regulations. My lord, that then is that aspect, which is responsible for a significant number of those millions of exclusions that we looked at earlier. Now come, my lord, to the end of that decision-making process, the appeal. And this sits, my lord, in Regulation 6. And in particular, Regulation 6C, my lord, which provides when lodging an appeal, the applicant or the person acting on his or her behalf may not submit any evidence or information which was not provided to the agency at the time of the application. So it bars any new evidence or any new information at the appeal stage. We understand from the affidavits of the department and SASSA that in practice how appeals are run then is that the same system is just put into place. It's just put into play. So the database and bank verification is run again. The only difference, my lord, is that it may happen 2 or 3 months later, and they will use the databases as at that date. So to the extent that any appeals succeed, it's because in the meantime, the databases have been updated. But by and large, it's just a rerun of the first decision. No application of mind and no real opportunity we submit for success on appeal. And my lord, that emerges very powerfully from the facts. And we would take your lordship to 002425. document is, again, a briefing by the department and SASA to the provincial to the parliamentary portfolio committee on 15 February 2023. FA 59 document begins at 002397. The part relevant to appeals appears 425. It begins at 397. The relevant page is 425. Status of appeals April 2022, indeed, my lord. And I'll take you through a series of these, the monthly updates on appeal outcomes. In fact, the first one is an outline. April 2022, 910,307 appeals for the month, just under a million. And then an indication against different databases of whether the appeals succeeded or not. So you can see what's happening. The database is just rerun. And we see SOCPEN, all 1,164 appeals declined. UIF, 1,635 approved, 7,962 declined. NESFAS, all 18,169 declined. PERSOL, all 6 appeals declined. DUPF, all 402 appeals declined. Inmates, all 140 appeals declined. PERSOL, 141 approved and 9,530 declined. Dean's test, 172,776 approved and 695,338 declined. SARS, all 3,014 declined. So a total of 177,000 were approved in that month. That's 19%. But my lord, as we take you through the rest, that is an absolute outlier. And it seems to have been explained by a significant number of means appeals succeeding in that particular month. But if we go over the page, my lord, to May 2022, you see a similar number of appeals, over a million now, 1,296,000. Then under all of those categories, the same databases went out. Essentially, all of the appeals are declined, save for out of the UIF appeals, 3,000 or so are approved, about 7,000 declined. PERSOL, about 1,000 recommended, 8,820 declined. Dean's test, about 15,000 approved, and 1,250,268 declined, making a total of 1.54% that were approved, appeals that succeeded, out of over a million, out of 1.3 million. Lord, it continues in similar vein, June 2022. That month was a lower number of appeals. That was because there'd been an interruption to the regulations, so there was a lower number of applications. There were only 500,000 appeals that month. 2.9% were successful. And my lord, if we then move forward a little bit in time, take your lordship to page 528, 002528. These are the next 3 months later in the year. July, August, and September 2022. In October, 4 months, my lord. This is 002528. It is Annexure FA 74. It's again, this is an SRD forum meeting, presentation by the Department on status of appeals. Lord, on 528, we see for July, over 1.5 million appeals. Again, under the various categories, all of the appeals are declined, except for a portion of the UIF, the portion of the PERSOL. Overall, 0.5% of the appeals were approved. That was about 7,500 out of 1.5 million appeals that month. August, over the page, my lord, similar picture. Just under 1.5 million appeals, 9,000 were successful, that's 0.6%. Most of the 1.5 million rejected, September, 1.36 million appeals, 11,000 were approved, representing 0.81%. And in October, it's more or less the same, 1.5 million appeals, 12,000 approved, representing 0.83%. And indeed, we do have November also. It doesn't, but that's the November report. Those appeals are still pending. They haven't been processed over the page. So, my Lord, what is apparent is that in that most recent range of 4 months, the success rate of appeals is typically below 1%. The number of appeals is invariably above 1 million, sometimes as high as 1.5 million. And you're seeing entire categories of appeals against the particular databases just being rejected again. Now, again, my Lord, we accept that in any reasonable system, there would be a proportion of appeals that would succeed and that would fail. It might even be likely that more appeals would fail than succeed. But, my Lord, that 0.5% to 1% success rate we submit demonstrates very clearly that there is a serious problem with the system of appeals. It's our understanding, my Lord, that they are effectively a rerun of the initial process, so that it's feeding the same person into the bank databases and into the databases and bank verification. That's our understanding. So it is significantly automated. So, my Lord, what then are the positions of the respondents in relation to the appeal issue? It's our understanding, my Lord, that National Treasury concedes that this regulation is unlawful and falls to be struck. And we do anticipate that they will argue that that will solve a lot of the problems. I'll deal with that in a moment. We do submit that fixing the appeal issue is important and that it's likely to benefit a significant number of people. DSD's stance, my Lord, DSD and SASA, their stance is that, well, then it's not an appeal because appeals don't involve new evidence. It seems to be a first principles based response. And our submission, my Lord, is that that fails to appreciate the range of different types of appeal that exist, in particular in relation to administrative decision making. The distinction between wide and narrow appeal, and that with administrative decision making, it is often appropriate to allow new information on appeal, and that is routinely done. We've given some examples in our heads of argument, my Lord, where other areas of the law, other regulatory regimes allow this. They include refugee status, breaches of financial sector laws, and various tax matters. So it's in quite a wide range of locations. There are many, many more examples. It's common. And my Lord, the issue here is that the injustice that is done to grant applicants by barring them from putting up any new information on appeal. One only needs to consider the process from their point of view to understand how unfair it is. So you're an applicant, you apply, the decision is negative because of UIF or income source, which tend to be the frequent bases for exclusion. So it's databases or income. You may have no idea. Many of our supporting affidavits say they don't know why they were rejected, but you may have an idea, or you may learn from that decision. Oh, I appear on NSFAS. One of our supporting affidavit deponents explains, I got a decision that says I'm on NSFAS. I did try to register as a student, but I never got any NSFAS funding. My registration didn't go through with the university. I've never had NSFAS funding. So if you get a decision like that, a very easy matter then to put up one page in your appeal to show that you never received NSFAS funding, a letter from NSFAS, which would resolve the issue. That person would then be successful on appeal, they would receive their grant. So there's quite a straightforward fix on the appeal issue, my Lord, which is to allow allow that where it's appropriate. In some cases, it won't be necessary or appropriate, but in many instances, that would fix the erroneous first instance decision making. Now, my Lord, I did indicate that I would. That is the approach of DSD and SASA. Yes, my Lord. Now, there may be an argument whether NSFAS funding constitutes income or financial support. We're not there. The difficulty that we're dealing with right now is that there are people who are listed on the NSFAS database who've never received funding from NSFAS. And one of our supporting affidavit says. My Lord, yes, it may be a matter of timing, my Lord. So if you're a student and you are currently receiving NSFAS funding that month, let's say, and it has come into your account payable monthly or termly, depending on the NSFAS system in your area. If you've received that, that would disqualify you from applying for the grant. If you've reached the end of your studies, you finished 2 years ago, you're unemployed, as is the reality for many people. You may still appear on the NSFAS database. And the database appears to work by registering people when they apply to NSFAS. It isn't fine-grained enough to determine whether they've actually received money or not. It's just, is your ID number on the NSFAS database? If it is, you're rejected. And that's a problem in the first instance with the database, that issue that we raised, but it's also then a problem because you can't fix it even on appeal. Because when you get that negative decision, you can't appeal and say, but I graduated 2 years ago, or I never received NSFAS funding. See this letter from NSFAS, this one page. So the issue goes to both. The two problems are interrelated, my Lord. Problems with the databases and bank verification and the appeal, and they aggravate each other. Basically, as we can see from the stats, my Lord, if you are wrongly excluded at the first stage by the databases, you have almost zero chance on appeal, less than 1% success rate. So, my Lord, we submit that this challenge is well made and that there is, again, a simple fix. It's a simple textual fix, which involves just excising the word not from the regulation so that persons who seek to appeal may indeed rely on new information where appropriate. Well, that's the appeal issue. Now need to deal with the final one of the regulations that constitutes a barrier. And this is the regulation that provides, it's regulation 5.3, it's the budget cap on paying beneficiaries. And what this regulation says, my Lord, is that all payments in terms of these regulations are limited to the amount appropriated for the current financial year. The effect of that, my Lord, is that once those funds have been exhausted, SASA will not pay the next successful approved beneficiary who is in the line. So perhaps it's month 11, and typically we've been around 8 million approved beneficiaries. The budget cap, the budget has been tightened down to that number, as is Treasury's approach to try to reduce it closer and closer to the number of actual beneficiaries each year. And that line is reached. You are successful applicant, number 8,000,001. But because you came 20 minutes after applicant number 8 million, SASA will just not pay you. Now, we submit that this is obviously arbitrary and an obvious violation of the right. The main response from the respondents seems to be, well, it hasn't happened yet. But, my Lord, with respect, that is not a defense to an unconstitutional regulation. It suffices in terms of Section 38 of the Constitution that a right is threatened for a court to grant appropriate relief. And the right is threatened. that regulation is in force, and we know that Treasury is working concertedly to bring the budget allocation as close as possible to the actual number of beneficiaries. So they're actually targeting that line, which they say is their approach to budgeting. And so there is a real likelihood that persons would be excluded by Regulation 5.3. It is difficult, my lord, to appreciate what other justification there could be for such a regulation that says, well, when we reach the allocation in that year, after that, no successful beneficiaries will be paid. We'll just stop. And my lord, that is not to detract from the importance of processes of budgeting and expenditure management. But we're not aware of any other system that operates like that, where a cap is reached and then the next beneficiary is just told no. So, my lord, that is the final challenge to the barrier regulations. Those all deal, my lord, with the pool of people who are currently being excluded from the grant. Whether that's around 8 million or somewhere above and below that. And we submit that those regulations, those impugned regulations, are operating in different ways as the barriers to eligible people. The remaining two issues for me to address, my lord, relate to the people who actually do qualify, who do get the grant, for the most part. That's the grant value and the means threshold. I'll begin with the grant value, my lord. My lord, the factual position is that for 4 years, the grant value remained at 350 Rand. It was the only social grant of all of the grants administered by the respondents that did not receive annual increases during that period. Every other grant received annual increases. Only SASSA was kept at 350 Rand, and it was kept at 350 Rand, my lord, until finally late this year, the 20 Rand increase was announced by the Minister of Finance and then implemented. Now in the 5th year of the grant. And my lord, Treasury, as we understand it, accepts the proposition that maintaining the grant at 350 Rand amounts to a real terms reduction, simply because 350 Rand in 2024 does not buy what it could buy in 2020. My lord, they also, as we understand it, accept calculations that we put up in the founding affidavit in terms of what the grant would have been in 2023 when we launched the application, if it had kept up with inflation. My lord, that is a figure of 416 Rand 96. And my lord, we've drawn your lordship's attention to the data that shows that the grant is mainly used for food. Food inflation is higher than normal inflation. The price of food products rises faster than other products. And so if the grant had kept pace with food inflation, in 2023 it would have been 449 Rand 25, almost 450 Rand. Because it didn't keep up with inflation or food inflation, my lord, its real terms value actually dropped below 300 Rand as at today. So it is equivalent, my lord, to giving less to grant beneficiaries year on year. Each year they receive a little bit less. And a good way to understand this perhaps is by thinking of the grant as a food basket. We know that 93% of grant recipients use the grant to buy food. Now, we also know that 370 Rand even is well below the food poverty line. So 370 Rand is not enough for a person to survive on in a month, just in terms of food. But if we think of that 370 Rand as a basket of basic food stuffs to sustain a person through the month, what it means is that from 2020 into 2021, perhaps we're removing one loaf of bread from what would have been half the month's food. So now you don't even have the half month's food, you have less. My Lord, it's our understanding that the respondents don't dispute this. They accept that it does buy less than it did, that in real terms it has gone down. It has fallen significantly below the food poverty line. And my Lord, the only increase was the 20 Rand increase, which the Minister of Finance announced this year in the 2024 budget speech, and which was implemented soon after. My Lord, your Lordship will recall that we dealt with the issue in our replying affidavit, then again in the supplementary affidavit. And we called on Treasury to explain why it is that after insisting that the grant as a whole is completely unaffordable, that no increase whatsoever could even be contemplated, 20 Rand increase was then implemented without prior announcement, without informing the applicants in these proceedings, without informing grant beneficiaries. It was simply announced more or less in the middle of the year, with the minister explaining in his announcement, well, that this is going towards progressive realization of the state's obligations. In the supplementary affidavit the Treasury has now put up, effectively what they offer as an explanation is that there was a reweighting of priorities. So priorities were reweighted, and that accordingly the 20 Rand increase was adopted, and that it will have impact on other expenditure, and they can't at this stage tell the court exactly what that impact will be. But we submit, my Lord, that that belated 20 Rand increase, the only one in the 5th year now of the grant, does not remedy the retrogression. Even with the 20 Rand increase, the grant is still far below where it would have been, even if it had just kept up with inflation, as the other grants did. And so there is an impermissible retrogression and a failure to progressively realize the right. And we say so, my Lord, for three main reasons. The first is the one that I've just given. The increase doesn't fix the erosion in the real value of the grant. It's too small for that. The second, my Lord, and this is perhaps most significant moving forward, is that even now in their supplementary affidavit, and in all of the affidavits of the respondents, there is no indication of a plan for the future. So the grant beneficiaries, having received the 20 Rand this year, now have no idea what can reasonably be expected next year. There's no indication of any plan at all, or even that a plan is being discussed or considered. Not even indicated that an increase is being considered for next year, or what the considerations would be in deciding whether an increase is to be made and what it might look like. And that really will go to our relief, my Lord, which I'll deal with in due course. The third reason, my Lord, why we submit that the grant value is unconstitutional is that the value of the grant remains arbitrary and irrational. Government has a series of poverty measures, the national poverty lines, the food poverty line, the lower bound poverty line, and the upper bound poverty line. And my Lord, it would be one thing for government to say, well, our view is that full realization of the right would be the lower bound poverty line. That's basically enough, my Lord, in crude terms, for a person to eat and to meet their most basic expenses to survive. It might be that government would say, well, that's what we consider to be full realization, but we can't get there right now. This is our plan to work towards that. It will take 3 years or whatever period. But there is nothing of that sort, my Lord. What we're met with is a stone wall, with Treasury saying the grant as a whole is unaffordable. No increase whatsoever can be considered. and a refusal to even engage with the national poverty lines. My Lord, those are the three primary reasons why we say the grant value is unconstitutional, why that regulation falls to be set aside. I emphasize once more, my Lord, that we do not seek to prescribe that grant value. We do not come to court as the applicants to say that it should be X rand, nor do we invite the court to embark on that exercise. What we seek is an order requiring the respondents to come up with a plan taking into account the relevant considerations relating to the value of the grant. Lord, I'll deal in a moment with affordability because it relates to both the threshold and the grant value. I must deal finally with the income threshold. The argument there, my Lord, is largely mirrors the grant value argument, but there are some significant differences. Your Lordship will recall that the means threshold is 624 rand. That increase, my Lord, came as a result of the Black Sash litigation and the settlement in 2022. That is the only increase that there has been. There have been no increases since then. And in relation to the means threshold, the threshold actually was set at the food poverty line in 2022. At that time, it was, I beg your pardon, my Lord, the 2021 food poverty line. So the minister in 2022 used the 2021 food poverty line of 624 rand. But my Lord, in the meantime, the food poverty line has risen. The income threshold has remained the same. Now, the effect of this is a little bit different, my Lord. If the grant value is a food basket and you've got less food year on year than you had before, the income threshold is like a rising tide, my Lord. And if that threshold is kept at the same level as inflation or linked to a food poverty line, all the beneficiaries rise with it. So a person at the food poverty line in 2020, who maybe has a modest increase with inflation in their income by 2023, will still qualify because the means threshold goes up. Everyone rises with that threshold. If the threshold remains the same, the beneficiaries drown under that line. Basically, a person who qualified in 2020 no longer qualifies in 2023, even though they've only had a modest increase, even less than inflation, in their income during that period. So that's the real difficulty with the means threshold. And we submit that it is also retrogressive, because in real terms it's not shifting. And it has become delinked from the food poverty line. And so it's arbitrary for that reason. My Lord, again, we make note that every other social grant that is means tested had the means test increased each year. It is only this one that didn't. Lord, that then is our challenge to the means threshold. The final issue I need to deal with is the argument on affordability, my Lord. We've dealt with the temporary issue in response to your Lordship's question earlier. It's our understanding that the respondent's case really rests on those two arguments. DSD and SASSA primarily advance the temporary argument, Treasury primarily the affordability argument, although both of them seem to endorse both arguments to some extent. On affordability, my Lord, we have quite a simple response to Treasury, because there is a great swathe of issues and information relating to the general status of the country, the debt burden, other demands on the fiscus. Lord, with respect, those are irrelevant to the questions that your Lordship has to decide. They're irrelevant, my Lord, for two reasons. First, they're irrelevant because there is a misleading proposition that expenditure needs to be linked to a particular revenue source. In other words, that a particular source of funding needs to be found for the SRD grant. Lord, that's simply not how the budget process works. Expenditure is not linked to a particular revenue source. When schools are built or hospitals are staffed, there isn't a specific tax that we pay that covers that particular expenditure. So that suggestion is misleading. What's really going on, as Treasury confirms in their supplementary affidavit, is a weighting of priorities. The second reason, my lord, why all of that broader macroeconomic picture is irrelevant is that Treasury's defense is effectively a generic one, the defense of unaffordability. It could, my lord, be copied and pasted into any other social rights case to say that we cannot afford to fix pit latrines in rural primary schools, we cannot afford to employ more nurses, we cannot afford to provide alternative accommodation or land to landless communities. It's generic in that way, at that high level, when it operates at the high level. The only relevant inquiry, my lord, is whether there is some absolute barrier to affording any increases in relation to the SRD grant. In other words, is there evidence that shows that not a single cent more can be spent on the SRD grant? And my lord, we would submit that there are two facts that show that in fact the opposite is true. That in fact there is substantial room to move. And those two facts, my lord, are first, the historic underspend throughout the life of the SRD grant. Underspend coupled with budget cuts, that's the first fact. Take your lordship to it now. And the second, my lord, is the increase this year, the 20 Rand increase. My lord, if I can deal first with the underspend, that appears at National Treasury's answering affidavit. We deal with it too, but this is their account of it. At 008-49. And these facts are all common cause. It's just the figures that I need to provide to you. So, Lord, 008-49, this is paragraph 77.2, National Treasury's answering affidavit. And Lord, this is indicating that in 2022-23, budget allocation for the SRD grant was 44.4 billion. And during the course of that year, it was reduced to 38.9 billion in an adjustment mid-year because it was not being fully spent. So 44.4 billion was allocated in 2022-23. It was reduced during the year to 38.9 billion. Lord, if we move forward in time, next events appear at page 27 of the same affidavit, 008-27. We then have, my lord, the budget in 2023-24, 36 billion, and the budget in 2024-25, indicative 33.6 billion. And we would emphasize further, my lord, that at the time of deposing, this is paragraph 49, Treasury says that at the time of writing, the grant budget is still underspent by approximately 2 billion based on October in-year monitoring information in 2023-24. So they were anticipating when they deposed another underspend that year. So if we take as the starting point the 44.4 billion allocation, what we've seen, that was the amount the Treasury determined in 2022 was affordable, could be located, could be allocated to the grant. What has happened since then, my lord, which is very clear from Treasury's own account and DSD, is that conditions have been imposed to push the numbers down. As a result, beneficiary numbers have dropped even below DSD's target of 10.5 billion, closer to 8 billion. That's resulted in repeated underspending every year, and underspending currently even in the year as the affidavit was deposed to. And Treasury has responded again each year by cutting the budget further. My lord, what that indicates, my lord, is that the resources were available, they've been identified by Treasury, and this court doesn't need to determine how much precisely Treasury needs to allocate. This court's task is to determine whether the regulations are consistent with the Constitution or not. And then Treasury has the role of budgeting accordingly. Lord, we said there were two facts. That's the first, the historic underspend and budget cuts. The second is the 20 Rand increase. And my lord, that is conduct that demonstrates that resources were available. So this is Treasury saying, grant unaffordable, no increases can even be contemplated. None of the relief can be afforded. So, indeed, my lord, and that will ultimately be an exercise for them. There's one submission I must make about our relief here, which is that we accept that affordability is relevant. In our order, it is one of the factors that we say the respondents must take into account when developing a plan for the grant value and the means threshold. They will take into account affordability, and they will do so in consultation with the Minister of Finance. What I'm dealing with now, my lord, is simply the claim that none of the relief is affordable. And that's an absolute bar to doing anything. They can't even think about an increase. My lord, following 4 years of successive underspends, that claim is unsustainable. If they've been underspending each year, they cannot come to court and say we cannot even contemplate increasing anything. And the underspends have been material and significant. So, my lord, those are our submissions on affordability. Well, my lord, in a sense, the money is reallocated or lost. But we submit, my lord, that process is one for Treasury to manage moving forward in consultation with the department. They will be doing it anyway. They're required to be engaging now on the current budget for the upcoming year in any event. They will be doing it anyway. The question is, can they say we will not consider any increase to the grant value and to the means threshold? We will not even consider one. We submit that having effectively retrogressed those values over these 4 years, it is unconstitutional for them to do so. But, my lord, we emphasize it's not for your lordship to find the money or to determine how much needs to be spent or where it needs to be reallocated from. Those will be processes appropriately left to National Treasury. Lord, those then are my submissions on my portion. With your leave, I will yield to my learned friend, Mr. Mbikiwa, to deal with the issue of non-payment and return very briefly at the end on remedy and costs.
May it please you, my lord. Lord, I will deal with what we've been describing today as the non-payments issue. That is the part of the applicant's case that seeks relief in relation to SASSA's delays and failures in the payment of approved beneficiaries. And I stress the word approved, my lord, because we are talking here about recipients who qualified for the SRD grant under the existing regulations and who have been approved for payment, but who SASSA has failed to pay. I'll address you on 4 topics, my lord. I'll begin by situating this relief within the context of the case as a whole. I'll then deal with the facts regarding non-payment. And what I will demonstrate to your lordship is that on the common cause evidence, more than 1 million people per month who qualify for the grant on the regulations as they stand and who SASSA has approved for payment do not receive their grant either on time. Third, my lord, I will deal with the justification advanced by SASSA and the department for these failures. My lordship raised that justification with my learned friend earlier, and I will address that. And what I will show to your lordship is that the alleged reason that the department and SASSA put up in their affidavit is unsupported by evidence, is in fact contradicted by evidence that SASSA itself has put up, and lacks any detail or specificity. It simply does not adequately explain the degree of non-payment. And lastly, my lord, I'll conclude very briefly with submissions on the need for clarity and structural relief in order to remedy the breach in relation to non-payment. So I begin, my lord, with situating this issue in the context of the case as a whole. And if I can just orientate your lordship by taking you to the draft order that was handed up this morning so that I can focus on the particular prayers that we are dealing with here. You'll see at page 01511 at prayer 14, the applicants seek declaratory relief to the effect that SASSA's failure to pay successful applicants for the SRD grant timeously or at all is unconstitutional and unlawful. At prayer 15, it is directed that SASSA must investigate the cause of widespread delays in payments to successful SRD grant applicants and devise and implement a plan to address these delays. Prayer 16, SASSA is directed to deliver the plan referred to in 15 within 2 months and implement the plan without delay. And lastly, in prayer 17, the applicants are entitled to re-enroll the matter to papers to seek further relief if necessary. Now, my lord, the first thing to emphasize, just by way of framing, is that this relief stands entirely independently of any of the other relief sought in this application. It doesn't depend in any way on the lawfulness or validity of the regulations as they stand. And that, as I've emphasized already, is because we are concerned here with beneficiaries who have qualified and been approved under the regulations as they stand. The second issue by way of context is that this part of our relief is opposed only by the department and by SASSA. National Treasury does not oppose it. In fact, they say in their answering affidavit that these facts lie outside of their knowledge and outside of their legal interest. So it is only the department and SASSA that have any interest that opposes this. And relatedly, my lord, there can be no suggestion that this relief has any budgetary or fiscal or financial considerations. Treasury raises those in relation to the validity of the regulations, but those issues do not arise, are not raised in relation to the non-payment of existing beneficiaries, and nor could they. So, my lord, let me deal with the facts. And I don't intend to take you through the detail of our founding affidavit where the facts regarding non-payment are set out in some detail, you'll find that I'll just give you the references, my lord. That's 002-99 to 002-101, paragraphs 240 to 247. But where I would like to take you, my lord, is somewhere my learned friend, Mr. Brickhill, took you earlier, which is table 2 in the applicant's founding affidavit. And my lord, that you will find at 00249. And 00249 is a table of grant applications, approvals, and payments as of May 2023. Now, you'll recall that the application was launched in July 2023. The most recent data that existed at the time went up to May 2023, about 2 months before the application was launched. And what the applicants explain in the preceding paragraphs is that this data emerges from SASSA and the department itself. So there can be no dispute about the numbers in this table, and there is no dispute. And what I would draw your attention to, my lord, is in particular the last 2 columns of that table. The last 2 columns being paid as a percentage of approvals and number of applicants approved but not paid. And what your lordship will see there is that it begins in April 2021 with 85% of approved beneficiaries paid. From 2021 onwards, it's at 100%, 99%, and then the percentages begin to fall. So that when you're at September 2022, you've got 88% of beneficiaries have been paid. And by the time you get to May 2023, the most recent data prior to the launch of the application, 84% of beneficiaries had been paid. What that means is that 16% of approved beneficiaries had the most recent, according to the most recent data available when the application was launched, not been paid. Now, my lord, SASSA has in fact provided more recent figures in its supporting affidavit, which was filed together with the answering affidavit by the department. And if I can ask you to go to the annexure to that affidavit at SA1, which you'll find at 01025. The font is not very clear, but I hope your lordship is able to read it. (010-25). And what your lordship will see there is down the left-hand side, number of applications received, number of approved applications, etc. And if you look at the last 2 rows of that table, number of unpaid approved applications, number of applications paid, and you go along to the final column on the right-hand side, that is September 2023. That is the most recent data prior to the filing of the answering affidavits by SASSA and the department. What you'll see there is 1.2 million beneficiaries not paid, approved beneficiaries not paid in September 2023. That is the most recent data on the papers. Those are the facts that we know, that 1.2 million people in the most recent month we have data for were approved and did not receive their SRD grant. And my lord, in fact, to appreciate what this means, numbers tell us a lot, but the dire human impact of not receiving your social grant of 370 Rand in a particular month is vividly described in the beneficiary affidavits, which the applicants attached to their founding affidavit. And they are dealt with in some detail in the founding affidavit itself, but if I can just refer your lordship to 3 of those affidavits which relate specifically to the issue of approved beneficiaries not being paid. Joyce Somo applied for the SRD grant in September 2022. The reference to her affidavit is at 002537. Notwithstanding being approved, she was paid out inconsistently from January 2023 onwards. Some months she would get it, some months she wouldn't. She has no idea why. She's unemployed, she has a toddler, and she uses that, what was then 350 Rand, to buy food, clothes, and other necessities for her child. And when she doesn't receive that grant, she cannot get those necessities. Makaya Zolani, that's at 002571. Applied for the SRD grant, received the grant until February 2023. After that, she received no payments in March and April 2023, even though she was approved on the system. And she made inquiries in May 2023 and was confirmed to her that she was approved. She does not know why she stopped receiving payments, and she is unable to put food on the table in months where she does not receive the grant. Charmaine Natasha Asia applied for and was approved for the SRD grant. She hadn't received the grant since 2022. Apologies, my lord, 002-591. She says she has nothing with which to support herself and has to rely on handouts. My lord, the list goes on. The applicants attached 80 beneficiary affidavits to their founding papers. They summarized 13 of those in their founding affidavit, which related specifically to the issue of non-payment. And those beneficiary affidavits, as my learned friend Mr. Brickhill explained, have basically been ignored. In fact, in the department's case, they are worse than ignored because they are treated disdainfully. What the department says is that the SRD has over 8 million approved applicants, and the applicants can't rely on 5 individuals and allege that the circumstances of those 5 individuals speak for the circumstances of others. Well, firstly, my lord, we put up 80 affidavits, not 5, and at least 13 of those dealt with this specific issue. Secondly, the applicants have put up both statistical data showing 1.2 million non-payments every month, as well as individualized evidence to show the impact that it has on individuals. And thirdly, my lord, one would have expected that what the department and SASSA would do in response to the receipt of those beneficiary affidavits was investigate those particular cases and tell us on affidavit why it is that those particular beneficiaries hadn't been paid. But we see not a word to that effect. So, my lord, what we have here at the level of fact is strikingly similar to what His Lordship Justice Nugent described in the case of MEC for the Department of Welfare versus Eastern Cape versus Kate. The case is in the bundle of authorities. You'll find it at 021916. And the relevant paragraphs are paragraphs 3 and 4. And what His Lordship Justice Nugent said was that the establishment by the state of a legislative and administrative structure, the making of social grants, and the appropriation of monies for that purpose, together go a long way to fulfilling the state's constitutional obligation. But by themselves, they are not enough. What is required, in addition, are reasonable measures to make the system effective. On that score, there has been conspicuous and endemic failure in the Eastern Cape for a considerable time. Well, my lord, we say that there has been conspicuous and endemic failure on a national scale for a considerable time in relation to the non-payment of the SRD grant. And that while the regulations go some way to fulfilling the state's constitutional obligation, in the absence of proper implementation, in the absence of paying those who qualify and are approved, the state fails in its constitutional obligation. So, my lord, those are the facts in relation to non-payment. What about the reason? What about the justification? What does the department and SASSA say are the reasons for beneficiaries who are approved not being paid? And your lordship raised that with my learned friend this morning, and asked if the reason that was put up by the respondents wasn't that beneficiaries had failed to provide information in relation to banking, and that is part of the explanation they give, and I will come to that in a moment, my lord. But where I want to start is the explanation that SASSA gave to Parliament very shortly before this application was launched. And you'll find that, my lord, at FA 60, at 002429. My learned friend did take you there for another purpose, but that is a briefing document to the Provincial Standing Committee on Social Development, the 23rd of May, 2023. Just 2 months. 002-429, my lord. It's FA 60 to the founding affidavit. And if I can start by asking you just to page within that document to 002440. And there, SASSA explains that there are essentially 3 ways in which beneficiaries can be paid, according to their preferred method of payment. An EFT via their own bank account, cash send, that's a particular avenue of payment, which uses a validated cell phone number, and then the postbank. Postbank created accounts where money is collected from retail stores like Checkers, ShopRite, and Usave, and Pick n Pay. So those are the 3 payment methods referred to by SASSA in this document. If I can then ask you, my lord, to turn to page 002451. And here the SASSA is dealing with historic payments. So in other words, payments in relation to months in the past where payments had not been made and beneficiaries who hadn't been paid in those months needed to be paid. And what SASSA goes on to do is to provide 5 reasons in this document why those payments hadn't been paid, why those amounts hadn't been paid in the particular month that they ought to be. So the first reason is at A, which you have in front of you. And that is where payment details changed and a new account was pending bank account verification. So that is where an applicant changed bank account details, and SASSA was awaiting some kind of verification from the banks, which is facilitated by National Treasury. That's the first reason they give there. Over the page at 002452. National Treasury, according to this document, my lord, submits, so new accounts submitted are sent daily for account verification to National Treasury, who submit that to the banks for verification. This is, it's not used. My lord, this needs to be distinguished from verification in the application process. I'm not talking here about verification in the application process. I'm talking about beneficiaries who are approved, who then change their payment details. They change their method of payment or change their bank account details. And what SASSA is saying is that those new accounts get sent for account verification. And SASSA, that's correct, my Lord. My Lord, based on this, I think behind the scenes, together with SASSA and DSD. And what they say is that the time to receive a response from the banks through Treasury is generally 3 to 5 days. So I'm referring you to this explanation, but it's really not an explanation for the sorts of non-payments that we are seeing in the statistics that I've already referred your Lordship to. That's what this is referring to indeed. If you go over the page, my Lord, to 002452, and here they refer to referred cases. These are instances where an approved application cannot be paid because there's some issue with the identity verification. Right, so that's the second reason that they give. And they say that clients are sent an SMS with a link to confirm their identity. Number 3, C, payments returned by the bank due to challenges with a bank account. These are cases where a particular beneficiary's account has been closed, hasn't been FICA'd, or for some other reason they can't receive money. But SASSA tells us there this accounts for very, very few cases. They say it accounts for about 0.15% of total approved beneficiaries. So that's not the major reason for these failures to pay historically. The major reason is what we've come to in the last 2 reasons. If you go over to 002453, D, cash sent clients. There, SASSA confirms that over 350,000 clients, they refer to them as clients, are awaiting payment from this channel since August 2022. They say a procurement process is being concluded to reactivate this payment channel. And they say that the number was over 500,000, but that it had been reduced to 350,000 by implementing various measures. May 2023, Marie. So sorry, my Lord. May 2023, and the application is launched 2 months later in July. So these are this is really the most recent information available at the time of launching the application. And then, my Lord, over the page to 002454, post-bank clients. And again here, 489,837 people awaiting payment from that channel. And what SASSA says in this note is that with a new method of disbursement through, yes. Many had not been, my Lord, and you will have seen that from the table in table 2 that I took you to in the founding affidavit, which went up until May 2023. You will recall there were months historically that were well below 100%, and that's an indication that in those months beneficiaries still had not been paid. And so what the final explanation they give is the post-bank clients. And what they say there is that a new solution is currently at the final stages of development and will be implemented as soon as possible. We don't know what that solution is or whether it has indeed been implemented. But certainly by the time SASSA filed its answering affidavit in November 2023 and had statistics up until September 2023, no problems had been resolved. In fact, 1.2 million people were still being excluded. Sorry, not excluded, not being paid, despite having been approved. So it's against that backdrop, my lord, that we need to try to understand what the department and SASSA say are the reasons for the non-payment of more than 1 million people per month. And for that purpose, can I ask you to go to the department's answering affidavit? It's 009-51. You there, my lord? It's 009-51, and if I could ask you to look at paragraph 166. In the teething period of the implementation of the current SRD grant as the result of the technical glitches that were experienced by SASSA, there were delays in the payment of the SRD. Okay, so SASSA, the department and SASSA attribute the failure to pay to teething problems in the early stages. But there is an attachment to SASSA's affidavit which says the most recent data shows 1.2 million people not having been paid. It has nothing at all to do with teething problems at the early stage of the grant. It's September 2023, precisely, my lord. However, those technical glitches have since been resolved, and the applicants have been informed of this position during the numerous public committees that were held between the respondents and the applicants. No attempt to explain how 1.2 million approved beneficiaries are not being paid if these technical glitches associated with the teething stage have been resolved. Paragraph 167. All the approved SRD applicants have since been paid. Lord, I'll pause there. We know that that's simply not true. According to the most recent data, at the time that this affidavit was filed, which is attached to SASSA's supporting affidavit, 1.2 million people had not been paid, only in the preceding month, never mind going back. Who have since failed to submit their bank details to SASSA, or those that SASSA has been able, sorry, I left out a few words. Let me begin that again. All the approved SRD applicants have since been paid, with the exception of the few approved beneficiaries, the few. One can only assume they're not referring to 1.2 million people in the month of September alone, who have since failed to submit their bank details to SASSA, or those that SASSA has not been able to verify their cell phone numbers that they want funds to be sent to, and those cases that has been linked and identified as perpetrators of fraud. My lord, it's a difficult explanation to make sense of, but what it doesn't do is engage at all with the explanation that SASSA provided to Parliament and which the applicants pertinently raised in their founding affidavit, that there are problems with the post bank and with the cash sent avenues for purposes of payment. There are clearly problems with them, and SASSA has told Parliament that there are problems with them. And so what the department instead does, instead of putting up any evidence in relation to the steps it's taken to remedy non-payment, instead of providing any updated statistics if they existed post September 2023, the department blames the beneficiaries. It lays the blame at the door of the beneficiaries, and you'll see that, my lord, at 009-52, paragraph 172. It is thus important to be emphasized that the duty lies with the SRD approved beneficiaries to give the correct payment details the longer they take to provide the correct verifiable banking details, the greater the delays. Lord, let me summarize the 4 reasons why the explanation that SASSA and the department give simply does not justify the non-payment of beneficiaries, which is common cause papers. Firstly, they provide no detail whatsoever. There's a conclusory assertion that those who haven't been paid is as a result of the failure to verify bank details. They provide no indication of how many beneficiaries are attributable to each of those alleged reasons. Second, even at the level of assertion, it lacks any credibility on its own terms. It's based on this notion of there being teething problems at the beginning, which had been sorted out subsequently, when the data shows exactly the opposite, that it's in the most recent months, up to September 2023, that more than 1 million beneficiaries have not been paid. Thirdly, it's directly in conflict with and doesn't address the explanations given by SASSA to the Western Cape Provincial Legislature in that document that I read to you in FA 60. And remarkably, neither the DSD nor SASSA say a word about the explanation given to Parliament in that document. Fourth, the respondents have failed to address a single one of the beneficiary affidavits. Those affidavits speak to endemic non-payment, and they explain the drastic consequences that it has for individuals. And as my learned friend explained earlier, the failure by the respondents to address those issues means that they are admitted to common cause. My Lord, that leaves only the question of what should be done, the remedy. I've already taken your Lordship to the notice of motion, or to the draft order rather, taken you through the prayers. Essentially, my Lord, we seek in the first instance declaratory relief, declaring that the non-payment is unlawful and unconstitutional. And my Lord, in our heads of argument, we refer you to the case of Rail Commuters Action Group versus Metro Rail, which is a case of the Constitutional Court, which tells us just how important declaratory relief can be in cases of this kind. It's in the bundle of authorities, my Lord, at 021-1236. And it's -1236. And in particular, paragraphs 106 to 109, which are at 0211258. And what 1258, I apologize, Lord. And what Justice O'Regan explained in that case was, firstly, that declaratory relief is an appropriate remedy under Section 38 of the Constitution in circumstances where a court finds conduct to be in conflict with the Constitution. Secondly, that and I'm paraphrasing the case here, my Lord. I'm not reading from it, but I've given you the paragraph. Secondly, that a declaratory order is a flexible remedy which can assist in clarifying the state's legal and constitutional obligation in a manner that promotes the enforcement and protection of the Constitution. And thirdly, that declaratory relief is of particular value because it enables a court to declare the law on one hand, but allow organs of state to allow the other arms of government, the executive and the legislature, to decide as to how best the law, once stated, should be observed. And really, that's what our remedy seeks to do, my Lord. It seeks to do that firstly through the declaratory relief, and it seeks secondly to do that through the structural interdict that we seek, which is, and it's similar to other prayers in our notice of motion, which my learned friend will conclude on. But it's all that the applicants ask is for SASSA to investigate the cause of the delays. Clearly, SASSA has not done a proper investigation of the cause of the delay. It is clear from its affidavit and from the department's affidavit that it does not know why 1 million people a month are not being paid on time or at all. And so the first relief we ask that flows from the declaratory is that SASSA must investigate the cause of this. And having investigated them, it must come up with a plan to address them. My Lord, it's relief regularly granted in matters of this kind. It's relief that's particularly been granted in the social security context, in cases like All Pay and Black Sash. But I'll leave it to my learned friend to address you on the principles related to the remedy. Lord, those are my submissions on the non-payment relief, unless there are any further questions.
We have, my Lord, we're working on the revised agreement around concluding by 4 o'clock, my Lord, and I will endeavour to do so. It remains for me, my Lord, to deal with remedy more broadly, the other relief that we seek, and briefly touch on costs. Lord, we've handed up a draft order, and I propose to take your Lordship very swiftly through it, just identifying those aspects that warrant comment. But really, there are discrete paragraphs that seek to remedy each of the unlawful regulations and then also the issue of non-payments. So, my Lord, paragraph 1 deals with paragraphs 1 and 2 deal with the online only issue. The first paragraph simply declares that regulation, the relevant regulation 3.2, unlawful to the extent that it provides for applications to be lodged on an electronic platform only. And paragraph 2 proposes a reading in to remedy that of the words or at the offices of the agency. The effect of that relief, my Lord, would be that applicants for the grant would be able to continue to use the online mechanism where that's convenient for them, and we anticipate that the majority would do so. But for those few for whom it's indeed so, we submit not, my Lord. It's when a declaration of invalidity is granted, reading in of text to remedy the extent of that invalidity is a remedy frequently granted. And I can identify some authorities for you in a moment, my Lord, but we don't expect our learned friends to suggest that that kind of remedy is in principle impermissible. They might quibble with what is being read in, or that it goes too far, but in principle, it's a permissible remedy, my Lord. Lord, paragraphs 3 and following, 3 and 4 then deal with income and financial support, while 5 presents an alternative. And your Lordship will recall that we seek on those terms, income and financial support, primarily just a declarative, tell the world what they mean. And we've offered what we say they mean, and we have invited the respondents to make their proposals in that regard. The alternative, my Lord, in paragraph 5, only arises if your Lordship finds that for whatever reason the terms can't be interpreted in that way, in which case they then need to be declared invalid, and the remedies need to be the interpretations need to be read in. We submit that doesn't arise, and your Lordship doesn't need to go there. The declaratives serve the purpose. It's just out of caution that we included the alternative. Paragraph 6, my lord, deals with the two problematic questions, and it simply declares them inconsistent with the Constitution and invalid. Those were the two problematic questions on the questionnaire. And we endeavored to show your lordship that the remainder of the questionnaire still does the job if those two problem questions are removed. And so that relief ought to be effective immediately. Paragraph 7 and 8, my lord, deal with the database verification and the bank verification, and declare both of those inconsistent with the Constitution and invalid. But it doesn't end there, my lord. As an alternative, we seek an order declaring the conduct of SASSA in applying bank verification unconstitutional and invalid to the extent that it is unable to identify income or financial assistance and erroneously registers income where no funds have been received, double counts intra-household payments, and or fails to take into account fluctuations in an applicant's income. And then, my lord, we seek an order 9.2 kicks in, directing DSD and SASSA again to file a report to court. And we allow 6 months, my lord, to file a report to court on what steps they've taken and what steps they intend to take to remedy the deficiencies. Again, allowing the applicants to respond. And until that time, directing DSD and SASSA to disregard the database and bank verification. So, my lord, there are two options. Paragraph 7 and 8 simply strike down the database verification and bank verification. If they are so unreliable that at present they can't be deployed, they would be struck down and SASSA would be left using the remainder of the criteria that it can use to decide applications, the other methods. The alternative, my lord, is the order directing them to investigate and file a report, and in the meantime not to deploy, effectively suspending bank verification and database verification for 6 months until they fix the problem. So those are the two options that we propose, my lord. In paragraph 10, my lord, we deal with the difficulty of there being no clarity concerning conflict between the two methods. So how are the different methods to be deployed? Paragraph 11, my lord, is the new evidence on appeal, and paragraph 12 provides the remedy. Paragraph 11 simply declares that invalid. Paragraph 12 seeks to remedy it by simply deleting the word not. And the effect of that, my lord, is that the regulation would then permit applicants, appellants, to rely on new information on appeal. Paragraph 13, my lord, relates to the budget cap. The provision that provides that once the allocated funds have been spent, SASSA can withhold payment to the next applicant in line, the next beneficiary in line. And we simply seek an order declaring that regulation inconsistent and invalid. That's the regulation that the respondents say has never been applied. It hasn't arisen. There appears to be no practical implications then of declaring it invalid. Paragraph 14, my lord, and the following are the paragraphs relating to non-payment, which my learned friend, Mr. Mbikiwa, has dealt with. And so I move to paragraph 18, my lord. Paragraph 18 is concerned with the income threshold, and paragraph 19 with the grant value. And those are declarations of invalidity of the relevant regulations. What follows, my lord, is what we propose as the solution. And it's a solution that seeks to respect the separation of powers and to give the departments appropriate space to resolve the issues relating to the grant value and the income threshold. So there is a declarator in paragraph 20 which sets out the obligations of government to devise and implement a plan to redress the retrogression in the value of the SRD grant and income threshold, and progressively increase the value of the SRD grant in Regulation 5.1 and the value of the income threshold prescribed in Regulation 2.5. And then paragraph 21, my Lord, seeks to give guidance on that process and to identify the factors that are relevant to that plan that we submit the Department, SASSA, and in consultation, the Minister of Finance ought to develop. And we submit that those relevant factors are the right to social assistance in section 21, as 27(1)(c), which is concerned with people unable to support themselves. B, increases in inflation and the cost of living. C, objective income measures, including those national poverty lines, Lord, the food poverty line and the lower and upper bound poverty lines, which are published by Statistics South Africa. D, the need to ensure that no one living in poverty is excluded from accessing the grant. And so those are the factors for the income threshold. The factors for the grant are similar, my Lord, and those are set out in 21.1.2. They again include the right. We've added, my Lord, the impact of the grant in addressing hunger. So the right to food in 27.1b we submit is relevant to setting the grant value, given that most grant beneficiaries use the grant for food. Again, the need to remedy retrogression, the real terms value of the grant in light of inflation and the cost of living, and the value of the grant. Now, my Lord, those are posited as relevant factors that the respondents must take into account. They don't predetermine an outcome, and they allow the respondents in our submission appropriate space and discretion to conduct the exercise that really they ought to be conducting anyway, which is to plan for the future of the grant. And my Lord, the remainder of the structural interdict in 22 and 23 directs the Minister of Social Development to deliver that plan to the court, implement the plan without delay. The period that we propose is 2 months, my Lord, and I'll return to that in a moment. And an order in paragraph 23 permitting the applicants to re-enroll the matter on duly supplemented papers once that plan has been delivered, if it becomes necessary. My Lord, we submit that that relief is uncontroversial in its nature and that it flows naturally from the violations and unlawfulness that we've identified. What then do the respondents say on relief, my Lord? PSD and SASSA, my Lord, unfortunately say effectively nothing on an appropriate remedy. We submit, my Lord, that as the key respondents in this substantive area, they do have a responsibility to provide assistance to the court on what appropriate relief ought to be granted if any of the declarations of invalidity are made. And we invite them to do so, my Lord, in their submissions tomorrow. National Treasury, my Lord, has responded and engaged in detail around the relief. And they've made two key submissions. The first is a suggestion that the relief offends the separation of powers. And the second is a proposal of suspension, that any declarations of invalidity ought to be suspended. If I might deal with the first issue, my Lord, separation of powers, very briefly, and I'll just provide two references. A learned friend dealt with it to some extent. Structural interdicts of this nature, my Lord, have become the standard form of relief in cases involving social security or social assistance. In the whole line of all pay cases and black sash cases, which are cited in our heads and included in the bundle of authorities, the Constitutional Court in particular has routinely included the elements that we've included. Direct the department or SASSA to come up with a plan, investigate, come up with a plan, report to court. That is the more modest form of that order, and that's the form of order we have sought. In fact, my Lord, the courts have gone even further than we seek to do. So in particular, in the Black Sash decision, my Lord, and this was Black Sash 2, at paragraph 76. I had that one reference. This is at page 50 of our abridged authorities bundle, my lord. And the case lines reference is 021-305. And it's just one example, my lord, to show that really we are not asking this court to go particularly far. In this Black Sash decision, my lord, which was again concerned with systemic issues around social grants, the court went so far, my lord, in paragraph 12, page 306 of the order. There are other elements, my lord, around reporting investigation similar to our order, but this is what I wanted to highlight. The court in paragraph 12 of the order appointed a committee of independent experts, external to government, to investigate the issue and report on it. So, my lord, that is a more extreme version, which stretches the bounds, perhaps, of the separation of powers, but it was considered appropriate by the Constitutional Court in that matter. Lord, what we do, by contrast, is to ask this court with respect to identify the violations and the unlawfulness, to identify the systemic non-payment, and then to direct the respondents appropriately in the exercise of their powers to identify appropriate solutions, to come up with plans, report to the court, and implement those plans. And with respect, my lord, that has become a fairly routine form of relief. The remaining issue, my lord, and this is the final issue, is the question of suspension. National Treasury suggests that if any orders of invalidity are made, they ought to be suspended, and that if any orders requiring plans are made, extensive periods ought to be granted. They suggest, my lord, that if you're with us on the grant threshold, the income threshold, means threshold, and grant value, the respondents should be given 2 to 3 years just to develop the plan on whether they're going to increase those amounts. And my lord, we submit that there's no basis for a period anywhere approaching that. We have proposed 2 months just to develop the plan, my lord. The implementation would follow. And we submit that 2 months is a sufficient period of time for DSD and SASSA, in consultation with the Minister of Finance, to come up with a plan around the grant value and means threshold and lodge that with the court. And my lord, to illustrate that the 2-month period is reasonable, that is approximately the period after all the affidavits were filed, the main affidavits in this matter, close of pleadings, within which the Minister of Finance and the respondents apparently took the decision to increase the grant by 20 Rand. So pleadings closed, affidavits were filed early in the year, and then in the Minister of Finance's budget speech, a matter of 2 to 3 months later, the 20 Rand increase was announced. So, my lord, they had gone on oath before that saying no increases can be contemplated. In the intervening period, it was a sufficient period of time for them to engage, plan, and take a decision. And we submit that 2 months is a reasonable period in those circumstances. Lord, those are our submissions on remedy. Our submissions on costs are made in full in our heads of argument. If we are successful, my lord, we seek costs, including the costs of 3 council, and we do so from April of this year on scale C, given the complexity and importance of the matter. And we've motivated for that in our heads of argument. Lord, we do submit that the matter is of a complexity that warrants 3 council. You have also, your lordship has also observed that 2 of us have presented argument in the matter. My lord, if as it transpires, we are partially successful on some of the issues, but not others, we accept that it would be a matter of the discretion of the court to weigh that proportionate success and we would seek costs in proportion to that level of success. If we are unsuccessful, my lord, if the court is against us on all of the relief sought, we submit that BioWatch applies. This is constitutional litigation in good faith, and no order of costs ought to be made. Lord, those are the submissions on behalf of the applicants, unless there are further questions.
Lord, we subject to your worship, propose that we start at 10 o'clock between my learned friends, Sasa and I. Sure, I think it's half an hour. But my estimate of my side of the argument is approximately 2 hours. My learned friend has indicated that she might require about 1 or 2 hours, so it ought to be comfortably accommodated.
Lord, we haven't yet heard their submissions, but we will endeavour to and we have made full argument today, Lord.
Lord, there has to be some limit. I mean, in a case like this, fair allocation is after 2 days, and both sides ended up equal time. The way it's going to work out is that our learned friends will have much more. My Lord, my learned friend suggests, but again, subject to your lordship, that our estimates turn out to be inaccurate. Ask your lordship suggested today to perhaps cut lunch in half. That should comfortably do. As your lordship pleases. That's what your lordship directs. We will prepare it now. But Lord, can I respect? I'm not speaking for myself. I can give you an assurance. My side. I will contain my honor. Close to submit to your lordship a document which we will work on overnight, which will capture all the references to my oral argument, which will save your lordship and my friends. We will attempt to be as focused as possible. So, Lord, between my learned friend and I, we have got a clear demarcation. In your lordship now, I will be dealing with the attacks on the regulations and the request for a structural interdict regarding regulation 17, prayers 17A/B. My learned friend for SASA will be dealing with the question of delays and strict.
Yes, my lord. We have discussed with my friend much about.
Lord, just to indicate our agreement with that approach and our commitment to confine our reply to half an hour.
That's a mistake.
My Lord, we did also just want to indicate our thanks and apologies to the court staff for staying over time. We do appreciate it.
All right.